We are live. Yes. Okay. Sorry, guys. This has been a bit of a crazy day. Studio is not getting set up the way I was wanting it to, and having technical issues today. So it's been really crazy. I had set all of these. No, they were all in here. Where's my phone? Over here. Okay, I had this all set up. What happened? Okay. I had it all set up, you guys. I apologize. I do have a video I want to do right away. It's ready to go. It is from our Nevada judges from yesterday. I know, I'm Michigan prime time, and I'm going to do a Nevada case, or hearing, rather, but there's a reason. I made it, Allie. Are you kidding me? I made it to my own stream. Only, what are we? I don't even know. Oh, I'm only 5 minutes late. There we go. Woo! So, the reason why I am covering a case in Nevada is because I am not involved in this actual case, but essentially the same case was brought against me by the same, not defendant, not respond. Oh my gosh, I'm getting all my brain is just blah right now. I can't even think of what it's called. You guys, I have had some crazy weeks. We did some medication changes, and it's been messing with me for sure. The same litigant, the same person that filed the lawsuit, I think that's the case we're going to watch, is the guy that sued me for... Fritz, you can't just step, buddy. That just doesn't work. Now we're all messed up again. Bub, I know you want under the blanket. Hang on. I apologize, you guys. This is so completely unprofessional. Welcome to my world. This is my ADHD. This is literally like the physical representation of my ADHD life, which is it's crazy. Okay, Fritz, you want under a blanket or under a pillow? Is this what you are freaking out about? No, you are not getting no, you are not getting. I haven't even eaten lunch or anything. I have turkey sticks. You guys are going to get to watch me eat. I know, there's a bucket here. There's this curtain. I am literally in the doorway of my spare bedroom. That everything's been pushed in there after the holidays and everything. So anytime we got a box of something, because my parents, they moved, and so I got a lot of boxes of stuff from my childhood that I'm like, I don't know what to do with all this stuff from my childhood. I don't want to get rid of it, but I don't know what to do with it. Well, those boxes just got shoved in, and I'll turn the camera. You guys can see this. It's like literally Jenga. We have Jenga going on in our second bedroom. So yeah, that's the insanity of my world right now. I am in the doorway. I have bags of wool, huge, trash bags full of raw wool that's sorted, but needs to be washed. But because my health has been not good for a couple years, and although it's getting better, it got put in the room and forgotten about. I actually didn't realize I have as many fleeces as I do, because one, I bought specifically for my husband to process, for me to anyways, I didn't even know there was more of it left until I got in here. Yeah, it's crazy. But I have found my pearls, my pearl necklace, you guys. Oh, come on, attach. I hand strung and tied these pearls. I don't know how old they are, but found them. So I decided no matter what shirt I'm wearing, I'm going to put them on while I am officially being a journalist, news broadcaster, whatever you want to call me. Just don't call me late for dinner, and don't call me tabloid, because I'm not. Okay, let's get started on this case. So there we go. This one it's Todd Matthew Phillips versus, it's labeled Mark DeSiero and Dave Schoen. It's originally against, what's her name? Allegedly, this lawyer that he sued is my boss, I guess, is what he claims. What? I don't know her name. Can't remember it. Jennifer Abrams. That's it. Her name is Jennifer Abrams. Okay. Wait. I'm not muted, am I? Can you guys hear me? I don't think I'm muted. Yeah, I'm not muted. Okay, just checking. All right. Come on. Why don't you play? What is this? There we go.
The first order is this: no more motions by either side. No more motions.
Did it stop? It paused, didn't it? Sorry, guys. What is going on?
This is case number A829038. Phillips versus Abrams. Will counsel state their appearances, please?
Mark Swick, Your Honor, from Lewis Griswold for defendants Mark DeSiero and David Schoen.
Joseph Guerin from Lipson Nielsen on behalf of Jennifer Abrams.
Plaintiff? Can you hear?
Yeah, he's unmuted.
For the record, I have no idea who that guy is on the screen. He's not a party that I'm aware of. Sorry, that's Fritz.
He's gone.
Looks like he's not on.
He was there, but he's gone. We have Mr. Schoen. Mr. Schoen is here.
That's my client just watching.
Where's the plaintiff?
Your Honor, he was on a moment ago. It seems like his window's no longer on the screen.
No.
He might have to call in to, I don't know if he logged out himself or.
Can you ask him if he's gonna?
I need to turn my phone back on.
Okay, so while they're trying to get all this, I forgot that this happened. So this is a huge shout out to Alex Falcone from Our Nevada Judges. Alex is a good friend of mine. So I literally was on the phone with Alex right before I got on here. We were talking. So I was gonna put this video in later, but this is where we're at right now. So
Can you hear me, Mr. Phillips?
this is the man that sued me.
Yes, I
So
can.
you know.
Okay, let me start over. This is Phillips versus Abrams, case number A829038. Will counsel for the defense identify themselves, the ones in court, please?
Sure.
And who they represent.
Mark Swick from Lewis Griswold for defendants David Schoen and Mark DeSiero.
Your Honor, Joseph Guerin from Lipson Nielsen on behalf of Jennifer V. Abrams and the Abrams Law Firm LLC.
Mr. Phillips, would you identify yourself, please?
Yes, Your Honor. I am the plaintiff. My name is T. Matthew Phillips.
Okay, Mr. Phillips, thank you. Before I start, I want you to know that I have an order. It's dated. It's 23-00407. It's an administrative order from the Supreme Court of Nevada in the matter of the assignment of the senior judge. Memorandum of temporary assignment. Whereas the Honorable Jerry Reese, District Judge, is unable to hear the matter Phillips versus Abrams with the case number now pending in the 8th Judicial District. Now, therefore, it is hereby ordered that the Honorable Michael A. Cherry, Senior Justice, is assigned to hear any and all matters in Phillips versus Abrams.
What's your appearance on the record?
I'm here, Your Honor.
request that I do have a recorder and a marshal. And a
Sorry,
clerk,
guys.
so I
Yardstream
I have that.
reloaded on me,
And I have
and
this-
so
I
all
have
the videos
courtroom.
I had loaded
And,
to play are
this is
gone. So that's why
order dated,
that's why we're
February
doing
6th,
this one
2023,
first, because I'm
signed
trying
by
to
Judge
reload all the
Justice,
videos back on that I have
so
from
that gives
my
me the
mission
authority in this
cases.
case.
I apologize. This
I
is a
was sitting
cluster.
in
truck.
Judge Sturman's courtroom for her when she was gone, and her law clerk gave me this folder. I was able to get through some of it. It's when Mr. Phillips and counsel, it's when Judge Sturman had. the
Thanks,
case.
Poetic Justice.
And
I'm
there's some
trying to.
memos in here for the law clerk or whatever. This is the
This
file that I have.
face
at
blue
this point.
smiling. I don't know what that means.
I know
But
the facts of the case.
thank you.
I
I'm
just
glad
don't know
you enjoy the
status of
channel.
case. So I'd be glad to hear both sides as to what's the status of this case. Where are we? I know that this is a anti-SLAPP situation with them. I assume a motion to dismiss is pending.
There is, Your Honor. So
Please.
my clients, David Schoen and Mark PCR, filed a anti-SLAPP motion to dismiss. It was sometime in July of 2021. It might have been the 28th, if I remember correctly. And then it was set for hearing August 26th, 2021, in front of Judge Tim Williams. 28, 2021.
Sorry, guys. I only have one more to do. I
Judge,
promise.
Tim Williams on August, I think it was 26, 2021. He recused himself, and so the motion never got heard. There was a couple of reassignments that happened to different judges. We ultimately wound up in front of Judge Susan Johnson, who started oral argument on this. In fact, we got almost all. At like 10 a.m., so she continued it. Right after the hearing, about a week later, Mr. Phillips filed a motion.
Okay, I've got everything loaded, guys. We're good now.
Judge
Oh,
Johnson.
one might not be there.
And then she
Anyways,
said,
I've got my videos up.
We've been ever
So
since back and forth to different judges. We were in
they
front of Judge Sturman
essentially did oral arguments.
briefly. I remember
This has
she
been in
held
front of,
a-
I don't know, I've lost
hearing
how
sometime
many
in February
judges
2022,
they have had this
I think
case
it
in front
was,
of. It's been going on
to-
since
to talk
2021.
about how to schedule this. 'Cause there's so much chaos in the record.
And he's talking about
And
how
she ended up getting
it's been
taken off the case.
the
and
last judge,
there's multiple
yeah.
reassignments, and now here you are. So our motion has never been
Yeah,
decided.
success.
It was argued almost to conclusion one time already.
What is, Mr. Phillips,
And there is a transcript of that hearing.
what's your pleasure on this for me?
My
I believe that the
pleasure is
anti-SLAPP motion
to be done and
scheduled
have
for
him
today,
no
and
longer
I'm
harass
prepared to
me and other
argue
people that I know.
There are I know I made a motion to, I objected to some of the evidence. They had what I believe was some extraneous emails from third parties that weren't germane. And so to somewhat limit the scope of facts, I made some evidentiary objections. I was hoping that the court would rule on them before the day, but I don't think it's absolutely necessary because frankly, I don't think there's any way defendants can prevail. And respectfully, I'm eager to argue the case and eager to move forward towards justice.
Where's the transcript?
Just in
Somebody
case
got the
anyone's
transcript?
curious,
I have it.
his
I believe
idea
with
of
me, somewhere in my
what
binder.
justice is and what most other people's idea of what justice is in this case are two vastly different things.
It was fairly close. I mean, I don't know how much longer Mr. Phillips had to go because that wasn't stated on the record, but we came fairly close to getting a decision, and then he filed a motion to disqualify her or to have a recuser. So I don't remember what the motion was called. It was something along those lines. And then here we are now, about over a year later.
Okay, sorry. I'm going to pause this for a second. I want to put out my disclaimer. I always do it. I didn't put it in this. I'm not an attorney. I'm not making any legal conclusions. I'm not giving any legal advice. My comments are all my opinion, and all persons obviously are innocent until proven guilty in a court of law. So literally everything that comes out of my mouth is going to be my opinion and my opinion only. So therefore, I'll still have to say it all the time because I don't need another lawsuit for nothing. Anyways, let's get back to the video. I'm sorry I forgot. I'm not ADHD brain on fire for me today.
Transcript file.
The transcript was filed.
When was that transcript from, sir?
You know what, I think it was from September of 2021.
Okay.
Yeah, here it is. So the transcript was, we actually filed it in a document we filed on February 4, 2022, and the case was in front of Judge Sturman, I believe. The name of our document was Defendant's Joint Motion for Order to Calendar Case Management Conference. At the time, because our understanding was Judge Sturman was trying to get a handle, because Mr. Phillips has filed a tremendous amount of filings after the slab motion was filed. So we're trying to figure out what to do with all of that, although I think that issue may actually be resolved in a sense, because I saw the Nevada Supreme Court came down with an unpublished opinion.
Okay, so just for the record, one of T. Matthew Phillips, I guess you could call it a strategy that he does, is he files tons and tons and tons of motions. I mean, I know attorneys do it all the time, and you know, as he said, he's at his pleasure to file motions all day long if he wants to. That is some sort of a tactic to delay or confuse. I'm not sure. Just to be clear, I've never really had a conversation with T. Matthew Phillips. He messaged me one time a bunch, and we've had short little, like, twice, I think, interactions, like, and comments on Facebook and my Instagram. I don't know. It's been a long time. It's been several years ago. So, but it's still whatever. But to me, it's a tactic. I mean, you are allowed to file as many documents and motions as you want. His typical, what I've seen from him for his court cases, is he files a lawsuit of some sort, then he's constantly filing motions to dismiss the judges. And I mean, if you really didn't like a judge, I mean, that's smart. I don't know if that's why he constantly does that to change judges. I'm not sure. I mean, it's my opinion. This is kind of what I've, in my own brain, figured out as to how he operates. And if you know anything about me, I love trying to figure out why people are the way they are, why they do the things they do. Sorry, TMP, I'm not interested in you. And I mean, you have at one point made a claim that I'm one of your thousands or millions of adoring public or whatever. I'm honestly not a fan of yours. I'm sorry. I never knew who you were till you messaged me. I'm just going to keep saying that because it's the truth. Anyways, so yeah, that's why, like, this is the first case with this new judge. It was a special assignment. He was a Supreme Court judge for the state of Nevada. And I think that happened like right around when COVID hit, is my understanding listening to this Judge Cherry. So yeah, so this is their first hearing in front of this current judge. I know one of the big things is this like anti-slap motion that I believe Mark and Dave and possibly Jennifer also filed, or the Jennifer Abrams law firm filed, like an anti-slap motion. And I'm going to be very honest, I don't quite understand the slap and anti-slap stuff. It's not something that is in Michigan. We don't have any slap or anti-slap statutes. So I don't know anything about it. But yeah, okay, so let's.
Opinion in 2022, long after this. or maybe it was March of 2022, but it was the Vanna case, Vanna versus Daniel Simon Law Office, I believe. Court said that once the slap motion is filed, plaintiff can't file any additional complaints or anything like that. All the stuff he's filing is trying to change dynamic. I mean, if you look at the massive amount of stuff that's been filed in this case, it's all trying to inject new issues, new arguments, new facts. It's crazy. And I think that case is a hook that we can ignore all of that and just have you decide the slap motion, because that's what's supposed to happen. This is supposed to be a procedure that happens fairly quickly, where we get a resolution on our motion if we can show that we're entitled to slap. And that all this other extraneous stuff was delaying that, and because we didn't have a judge, we couldn't get a decision.
Did you do discovery on this case?
No, there's no discovery, because you don't get discovery in slap motion unless it's denied, or unless the plaintiff asks for discovery. But plaintiff never asked for discovery in this case. He has not asked for discovery. It's nowhere in any of the motions related to the slap itself, and that's where it would be required to be put in under the statute. So this is something that can be decided essentially.
Hey, Lana.
On
Thanks for
the
coming.
documents, less oral argument and whatever other questions you have. I don't know how you want to handle it, but I'm happy to argue it. Not a problem. I've come prepared to argue again, but.
I'd like a chance to prepare myself for this case. I was assigned, I was waiting to see if I was going to be preempted as to whether I was going to even have the case. I mean, they handed me this notebook, and then I picked the date of the 15th of March, which is today, and then I was told, no, you have to do it much quicker. So I picked 2 other dates, and then I was told, no, you stick with the March 15th. So and I've been sitting for a judge in Department 21, and previously Department 29, and previous to that Department 26, because of all the vacancies and problems we've had in the judiciary. So I really, I'd love to hear the motion. I'm very familiar with SLAP. Had a lot of those cases when I was on the Supreme Court, and I certainly would like to hear the motion. I just need a time, and I need to know if Mr. Phillips wants to be physically present for the motion. I'm not a fan of this blue jeans. Sorry. I mean, like today it was 15 minutes to get the plaintiff back on blue jeans. So what's the party's pleasure on? First of all, I'd like to read the transcript. Also, I think it's only fair that I get to read the transcript, and then I would let you argue again. You got the transcript? Okay.
My concern, Your Honor, is whenever there's been a delay, plaintiff keeps filing things. He filed 2 more things yesterday in this case. There's no briefing schedule still outstanding. So these filings are fugitive filings. He takes issue with the word fugitive, thinking there's no such concept as a fugitive filing in Nevada. It's something he's argued in front of Judge Sturman, which is obviously false. But the bottom line is, it seems like you may be able to just read this and give us a decision. If you think there's issues or questions you need to address, we could do that with you. If we go down this path at the end of the day, we're going to have more filings unless you enter an order that he cannot file anything else. I mean, it's not supposed to be like this with filing after filing. This is supposed to be an initial motion to dismiss, to have a procedure that gets rid of this case quickly. And this case, is a slap case. It applies 100%. I'm very confident you'll come to that conclusion when you read this. But we need something in order, because otherwise we're going to wind up with the same thing more and more and more. We can't do this anymore. It's cluttered the record. It's created too many problems. And yes, you run the risk that he'll file another recusal request. He's filed one almost every judge we've had.
Why haven't you filed motions to strike?
We have. The court hasn't ruled on anything.
I haven't seen those.
There's lots of motions strike, so that's why we didn't
I
file
haven't
any.
seen his motions, let alone the motions to strike.
Yeah,
So
that's why.
Let me start.
Everyone
over.
say hi to Luna.
It's only fair to me.
He's
I can
been
see everything.
Yeah, I hear.
I've got a notebook that
Curled
was
up.
given to me by Judge Sturman's law clerk. And
That
it
may
has
be as
stuff
far
in
as she got
20
with
and
this.
21 in it. I didn't even see anything in 22. It looks like nothing. I didn't see anything done in 22. And of course, nothing done in 23. But there's stuff that's filed that's not in here. So,
Judge, there are.
I mean, what I would ask is I'd ask a briefing schedule, first of all, on the motions to strike versus his plaintiff's responses to whether he could file. I'd say,
Well,
don't file anything else.
The
Let's get rid of the ones that,
the motions to strike, I think all that's already briefed. The only thing that wouldn't be briefed is new filings, which are again are fugitive. One of them was an issue dealing with the media
it's
order.
brief. I don't have the briefs. What do you want me to do? Pull it out of?
No,
I
of
don't
course
know.
not.
You're telling me there's motions to strike. I don't know if there's motions to strike. I don't know his response to the motion to strike. I don't know if he's got case law that says that he has a right to file these bookkeeper motions. So I want to start over. It's not fair to me. Otherwise, you're gonna lose another judge. I mean, give me a break. I want to do this right.
We're all for that, Your Honor. I just said it, but whatever's convenient.
The first order is this: no more motions by either side. No more motions.
Thank you.
But I need argument on the motion to strike versus the motions that have been filed as to whether I should even consider them before I read them. So let me have the briefing schedule on that, and then a schedule on oral argument on the motion to dismiss. The anti-SLAPP. What's good? I'm retired. I've got time.
I think we could probably just package everything up that's outstanding and provide it to the court in binders for convenience.
That's what I need.
And
I'm
then
used to binders.
maybe
I'm
you
the
assess
special
that
master
and
for
decide
the
if you need
opioid
anything
case.
else.
So I've got binders coming up to yin yang there. When can I have all this stuff? And Mr. Phillips, do you want to, of course, you want to respond to the binders. Do you want to make your own binder for me?
Yes, Your Honor.
Good. Okay. Defense, when do you want your binders to come to me?
Judge, if we could have until next Tuesday to get everything that's outstanding and copied, and we'll have it delivered to Your Honor in a binder, and then provide an inventory of what we've delivered to Mr. Phillips.
Everything is delivered here. It's going to make it a little easier for me. Okay, let's see. So the defense is going to deliver the binders. What date?
21st,
Phoenix
Your Honor?
building.
21st is Tuesday.
Mr. Phillips, when would you have your binders ready?
If it please the court, I would respectfully request.
We say it's Love
until
Luna,
March 2nd.
because he's full of love and she is love.
So you want to file them at the same time? The council? You want to file these at the same time? Because I'll give one date.
I guess the question I have, we should maybe talk about it, do we even need competing binders in the sense that it's all just stuff in the record, just putting a binder together of all the motions and all the filings?
Right, Your Honor, we're happy to take the labor.
Yeah, I mean,
to make sure
I
that
don't see
everything-
why, you're gonna get duplicative stuff like
If
that.
he wants to file a binder, that's fine with me.
Okay,
What date did you say, the 22nd?
Yes, please, Your
Okay,
Honor.
let's do both the 22nd. Let's have it by 5 o'clock on the 22nd to the Phoenix Building, 11th floor, Senior Judge Department. And that's going to include all the motions to strike, the quote, motions, and the transcript. Well, the clerk's going to give me the transcript, so I'll get that. I can have that within the same amount of time. And the motion for SLAPP, anti-SLAPP, and the opposition reply. I need all that. I don't have it, to be truthful with you. Okay, so that's March 22nd. Now, when are you available for argument? And I got to arrange a courtroom and everything else, and have the staff again. Mr. Phillips, do you want to come in for that? Where do you live?
Yes, Your Honor. Yes, Your Honor. I wish to say that I don't mean any disrespect by not being present.
That's, I understand. I just want to make sure that the technology is good. And what I find is that I'm having 12 years in the Supreme Court, and then they come back and have COVID, and we've got this blue jeans thing, is a lot of people make an argument, they turn like this, or they turn like that, or their technology's not good. Your technology seems to be pretty good. So I leave it to you. If you want to come to argue this, it's my pleasure to have you in the 8th Judicial District. These fellows are going to be here. These counsels are going to be here. It's up to you.
Yes, Your Honor. I would, and I didn't mean to interrupt you, but I do want to be present to argue in court, and any time from 2 weeks to 3 weeks to 4 weeks, whatever Your Honor recommends, is okay with me.
Okay, have everything by March 22nd. Let me be at ease. Everybody be at ease. Let me go get my stuff.
Judge,
I can do the 14th.
Let me see. Hold on.
If it pleases the court, this is the plaintiff, April 14th would be perfect.
April 14th looks good for me.
yeah, it'll work for me too.
Great.
I'll move my calendar, whatever I gotta do.
And how about 10 o'clock, April 14th? Ms. Clerk, where could we have this?
Go find the courtroom.
Pardon me?
I'm not quite sure. We'll find the courtroom and make sure there's no.
You'll notify the parties. We'll have the clerk has to get us a courtroom. She's dynamite, so she'll get it for us. April 14th, so that gives me time to read everything.
And is that?
And no more filing, nothing filed except your,
Right. Is that hearing absolutely everything that's pending or the first set of motions?
I thought you want to do everything.
Might as well get it on.
Yeah, that way he comes to town and it makes it easier, plus for me, it's gonna be easier. I can hear everything, and I won't put any time limit on this, so let's just see what we need. And if you're going too long, I'm gonna cut you off either side, so. But I'm also gonna read that transcript in advance, if you don't
And I
mind.
have a copy and have it given to you today if you'd like
I'd
it.
to love it right now. If you don't give it, that'd be great. That's one thing you don't have to give me.
If we go straight through, would it make any sense starting in the afternoon?
Whatever's convenient.
Whatever.
Would you prefer an afternoon, Mr. Phillips?
Whatever time is.
Like today, because today we started at 1:30.
How about 1:30 on the 14th? It'll make it a little easier for her to get a courtroom, I'll tell you the truth.
Yeah, that's what I was thinking, because it's probably about a few hours. So.
Yeah, they're moving everybody
Then we'll
around
run
right
lunch
now.
hour.
1:30 sounds good. I want to thank both sides for the cooperation in this matter, and I needed some cooperation on this.
Judge,
I just want to make sure that I get everything that I need before I,
For the binders, Your Honor,
please.
here's a copy of.
All right, Mr. Phillips, I'll get your stuff on the 22nd of March, and I will see you in Las Vegas on April 14th at, we're gonna have a 1:30 court appearance, and the clerk will notify you as to what courtroom it is. Have you been to any court?
I just realized I did that without first muting myself. So next, we are going to, actually, one of my videos is not, I think that is not the uploaded one I wanted. I'm going to see.
Calling case number 230.
That is the wrong one. I uploaded that same case twice. All right, so this first one, well, Fritz is being a jerk, is it's obviously here in Michigan. I forgot the judge of the magistrate. Let's bring it up. Why are we not playing? I know why I did it. Hang on, guys. I messed up. I disconnected my iPad. Gosh darn it. The hardest time finding the plug for my iPad. Okay.
Unknown caller.
Hold on. I don't even know who that was. Why won't this play now? It's gonna go. It worked earlier, you guys.
Unknown caller.
Okay. Why won't it play? Super weird. Okay. You know what? Let's just try it. We're going to try this again. I've never done it this way, so I have no idea. It worked before when I was setting it up this morning. It worked. So, Fritz, why are you digging on my boo-hiney, please? He's behind me digging on my pillow that I'm sitting on. Or those seat cushion thing. Open. There we go.
please place your appearance on the record.
Okay,
I'm here, Bobby Black.
this is,
Thank you, sir.
You're welcome. I'm very sorry for making that text. I really am.
someone that needs
I
to
didn't
learn.
realize what I was doing, but boy, I learned my lesson. You bet on that.
Hold on.
I don't think he understands his rights, or he's just not taking advantage of them.
Today's the date and time set for a bond hearing. Mr. Black,
Yes, sir.
this is, there was a $5,000 bond set for a violation of bond conditions.
I understand, sir. I know I messed up. I did. It would never happen again. You can trust and believe that. I mean, I'm a worker. I work every day when I'm out there. And I mean, I didn't realize that. But if I get a chance, I'll explain to you what I've done. But I'll wait till you come to.
Mr. Van Allen,
Your Honor, what was the bond condition that was violated? I'm not seeing it on.
I sent a text there. I wasn't supposed to contact her, period. And I
hold on, sir,
Sorry.
hold on.
I thought you were talking to me.
So I believe with Mr. Black's statement, he admitted to violating the no contact provision of this bond. Your Honor, Mr. Black does have a fairly extensive criminal history dating back to the 80s. I am seeing assaultive crimes throughout his history, given the fact that he's already violated the no contact provision of his bond. I do have serious concerns should this court elect to lower the bond or reduce it to a PR entirely.
I know I made a mistake. Yes, sir.
At this moment in time, my understanding is you do not have an attorney.
No, sir, I haven't had a chance to get out. I screwed up the first day I got out. I really did. I didn't realize how dumb what I'd done. Okay, I did.
Hold on, sir, hold on. Do you wish to be evaluated for a public defender?
I mean, I'll give it a lawyer. I can hire a lawyer if I get out, so I can go talk to Rob.
That is not what
Yes, sir. At this moment in time, we don't have an appearance, we don't have an attorney,
Okay,
and you're telling me that you're not able to get the attorney while you're in jail. Do
right.
you wish for a public defender to be evaluated for you?
Please, sir.
Right. I will order a public defender to be evaluated if you are eligible to, that it be assigned to you.
Okay. And again, I know where I made a mistake, and it will not happen again.
The prosecutor has a very valid point. Quite literally, you have an extensive history.
It's been a long time.
Well, it has been.
I tried to do right. I really have. I've been trying to do good.
Sir,
I've been trying to do
hold
good.
on. Hold on. But I do see in the past an assault and battery. Obviously, this is a domestic violence. I see another assault.
The domestic, I haven't been guilty on that one yet, and I have a video where she came at me. I have it on video. I just gotta get out and prove my case.
I'm not making any evaluations on
Okay,
the current
I
charge.
understand.
All I'm saying is you have a great deal of history with the
I
criminal
understand
justice
what you're saying, Mr. Martin.
And a
I
number of
understand
these
now.
cases.
I don't understand what
a
the
number of
judge is
these
saying because he
cases
won't
are
stop
assaultive
talking.
in nature.
And I've tried my darndest as I've gotten older to, right my ways. I have. And I'm trying my darndest to do right. I really am.
Well, sir,
Let me
I'm
know
going to
how the audio
reiterate
is on my
just
end.
You have
Can
a
you
no
well?
contact with Amanda
Is the
Black.
video loud
When I
enough?
say no contact,
Yes, sir. I understand what that means now. Believe me.
well,
I guess I was a fool, but not thinking a text wasn't contact. I don't know why.
sir,
Because you're a fool.
I understand,
I was a
but I
fool.
also understand the court has two primary concerns. One,
Okay,
if somebody shows up, then make sure that they appear for court.
I will be there.
Sir, stop interrupting, okay?
I'm sorry.
So the first is that somebody will appear for court. I've not heard anything that would say that you're not going to. The second is safety of the community. and with a domestic violence charge, specifically safety of the purported victim. Based on the history and based also on the fact that this was, well, March 10th is the date that I show the bond conditions being placed. And then I show
You're welcome. Is
March
it Elena,
10th in the
Alana?
afternoon is when the allegation of
Elena?
a violation of the bond conditions
I
took
don't. Am I
place.
pronouncing that right?
Now, that's very quickly violating the court's order when you had just been told no contact with
Can
the
I have a
purported
chance to
victim.
explain? One chance to explain what happened? When I got
Please,
bonded
Rick,
out,
remain
the
silent.
guy that bonded me out, his dad's gonna loan me the money to pay her for our divorce. And all I wanted to do is let her know that she was getting her money on that, you know, on such a date. And I know I messed up.
Hold on.
With the court appointing Mr. Black.
So he didn't know texting her was contacting her, but he was texting her to let her know he had the money for their divorce. That, sir, is very much so contacting someone. I'm not sure how he didn't understand that. I don't know.
Black or asking the public defender's office to inquire on whether or not Mr. Black qualifies for a public defender. I do have some concerns that Mr. Black has been repeatedly admitting to the contempt.
Elena. I went to school. I grew up with a girl named Elena, but she spelled it with an E, and that's why I was kind of wondering. All right, sorry, I'll not interrupt. I'll stop interrupting, guys.
Court violation, which does carry 93 days in jail, in which he would be entitled to an attorney on. I understand where Mr. Black wants to explain things, but if there's a possibility that an attorney is going to be appointed, I think it would be in everybody's best interest to stop any type of explanation at this point.
I'm sorry. I will. I'll shut up.
I would agree with you, Mr. Black. I do not wish you to
Okay.
basically make admissions without
All right.
potential.
I'm sorry.
Having. But at this moment in time, I'm not going to amend the bond on the criminal contempt. Obviously, your attorney can address that at a later date, but with the rapidity of the violation and the prior history, I'm not going to modify the bond at this time.
Staying in jail then?
The next court date for the pretrial and criminal contempt will be March 23rd at 9:30 in the morning. So if you do get out of jail, you need to be here at that day and time. Your attorney, or hopefully you'll be appointed attorney, and then you can talk to them.
I will be
That
here.
is all. Right. That is all in this matter.
So I don't got a bond then?
No, sir. You're not. Well, you have a bond, but it's still 5,000 cash or surety. So if you can make the bond, that's fine. But if not, then
Okay, so what I gotta do is get a bondsman in or something like that? I can't get it lowered any? But I mean, I got 3 properties here in town.
Sir.
Three 055955101. People of the state of Michigan versus Andre Neil Hardaway.
Sorry, I muted myself again. So a little preface about this case. This case has, I believe this is the $1 million bail case. It is crazy. I have not edited out any, like the victims' names, addresses, stuff like that. This is just straight. I cut out a couple minutes of pausing. So this is literally as it's playing. And just so you know, because of videos, because I cover cases like this, my videos do often get demonetized. So if you want to help support me, obviously liking my videos, sharing my videos, subscribing to my channel. I do have a members whatever you want to call that, memberships for my circle of friends. I also just launched my merch shop, which that's what's scrolling at the bottom of the screen is the link for my merch shop. And I have, I created the logo for Michigan Crime Time. Like I did it, I drew it. It's all I made it. So I've got shirts and other merch that has the logo on it. Even if you're not from Michigan, I have a little sticker. There's it looks like there's a lot of products. It's not the logo. I did the logo with the layout of the state and everything, different colors. So it wouldn't let me do multiple colors, so I had to do individual ones for each different color. But you can get stickers and you can like put it on your water bottle, whatever. That would be really awesome. I do have an item that it says Turtle Herd. And if you watch Judge Middleton and you love Judge Middleton, you will have heard his comments about it's like trying to herd turtles, or it's about herding turtles. So I designed a turtle herd shirt, and I love turtles anyways. But yeah, so I do have a turtle herd shirt. I am currently working on other images. I like literally have been working until in the middle of the night, working on creating these images in Adobe and all that other stuff. So that is what's going along the bottom is for the merch shop. If you guys want like Michigan Crime Time logo like customized with your name, let me know and I can make that happen for you. Let's get back to this case. By the way, this is DCC, so Detroit Detention Center. I'm not sure if it's Oakland, Wayne, or I forgot the other, Macomb County. There's 3 counties that encompass basically the Metro Detroit area. So I'm not sure where, but he's at the Detroit Detention Center. So he's like at the headquarters or whatever. All right, I'll shut up now.
Appearances.
Good morning, Your Honor. Matthew Penny, P74079 for the people.
And good morning, Mayor. Please, this honorable court, Darnell Barton, P83363 on behalf of Mr. Andre Hardaway. Sir, can you state your name only for the record, please?
Andre Hardaway.
Thank you. Your Honor, as it pertains to the arraignment, my client will stand for you any formal reading of the charges and ask you enter a not guilty plea.
For purposes of arraignment, not guilty plea will be entered on your client's behalf. Formal reading is waived as to bond.
Yes, Your Honor. If we could, at this point, we understand we're not going to waste too much time with the argument here. You've already seen the charges that are assessed. We would just ask for a reasonable bond for Mr. Hardaway to come out and be able to fight his charges if at all possible.
Thank you, counsel. APA Penny.
Thank you, Your Honor. The people are seeking $1 million cash bond in this matter. Defendant has been charged with multiple counts of shooting at police officers who were trying to arrest him on a valid felony warrant. The reason the police officers bluntly rolled heavy, they came with an armored team, was because in a previous search warrant that was executed at a previous residence that defendant lived at in Rival Village, they found booby traps in the house. They found a veritable arsenal, which gave rise to his felon in possession, felony firearm charges, for which he was being arrested.
So they roll out Bearcats, the big dogs.
When they went in, they knocked in and out their presence repeatedly. There's extensive body cam that corroborates that fact. Defendant did not submit to being arrested. Indeed, he ran into a bedroom, grabbed a .40 caliber pistol, and began shooting at the officers in a confined hallway. 2 officers were shot multiple times. Both are expected to survive and recover. However, they do have extensive wounds. The defendant himself was shot. Part of what concerns me about this, Your Honor, is after that initial search warrant that I believe was in 2021 and all those weapons were seized, the defendant apparently went out and found more weapons. There were 9mm, 40mm, and .556 caliber ammunition that were found. What expressly concerns me is there was a 9mm handgun recovered, a 40 caliber handgun recovered, but a weapon for that 5.56 ammunition has not been recovered. I've got no clue why he had so many magazines, loaded magazines with potentially armor-piercing ammunition, and not have that gun in the house there with him. He is a risk to the community. He is a risk to law enforcement if he were to be recovered. There are reports that at one point he maintained a YouTube channel that had anti-law enforcement information being placed on it. He apparently once said that when dealing with the police, you need to be prepared to use deadly force if necessary. All of these things were why the police tried to arrest him in the manner that they did. He's a threat to the community. He's a threat to law enforcement. We seek a high cash bond here, $1 million, please, Your Honor.
Your Honor, ma'am.
Thank you, APA Penny. Court has heard the representation of counsel and APA Penny as to the community, family, employment ties, one Mr. Hardaway, as well as the incident that brings us to this particular arraignment today. Court would note I do not have a CAPIS history for Mr. Hardaway, no indication he is a flight risk. I do have a prior criminal history for Mr. Hardaway, which reading the criminal history dating back to 1987, he has a couple of unlawful driving away convictions.
That's
out of the
that's
Sixth
serious
Circuit,
time, man. Like he's been
as
doing
well
this
as a
for a long time.
1989 escape from prison conviction out of the Sixth Circuit, as well as a 2002 conviction for felony firearm. The allegations against Mr. Hardaway gives this court some concern about the general safety of the community, as well as law enforcement. And reading the investigator's report, it is identified that Mr. Hardaway allegedly shot at law enforcement who were in uniform. It was a orchestrated and and many numbers of the police department, law enforcement who were part of this operation to apprehend Mr. Hardaway. So it appears to this court that it was quite clear that it was law enforcement who was attempting to reach him at this residence. Shots were allegedly fired at the law enforcement, striking two individuals. In addition, it concerns this court that allegedly Mr. Hardaway was not alone.
So if you're like into
that
fat
a
eating
wife and
food,
child was also
go ahead
there,
and start joining my
and
membership.
putting them in harm's way gives this
You can
court some
email me. I'll
concern
send you my PayPal link.
about
'Cause I'm about to
just the
some turkey
thought process,
sausage sticks.
obviously, of Mr. Hardaway.
Just so you know, if you're enjoying
did
it,
not have
I'll send
concern
you
for his
videos
own
of me
life.
eating.
But what about those of
I swear I don't do anything like
wife
that.
and child? When shots are being fired into the home, obviously, they could have struck any particular individual. This court has concerns about their safety as well. Looking at this prior criminal history, those are mainly nonviolent convictions, but it does give this court some concerns. Obviously, the type of convictions, and where before I said I do not have CAPIS history,
Thanks, Alex.
but I do have a conviction for trying to escape prison. unlawful driving away. So it gives
That
us
is
question
Alex from
concerning
Owen, Nevada
your
judges,
client, Mr.
guys.
Barton,
He's
may
finally
not
in.
follow orders of the court as well, given that prior criminal history. I do have concerns about the general safety, as mentioned, of the community as well as law enforcement, as stated. I must, as you both know, balance obviously the factors and information I have in front of me with obviously the likelihood of any type of conviction, with also your client's ability to pay as well. Mr. Barton, was there any type of bond that your client feels that he can post?
Your Honor, at this point in time, I don't have a specific amount, though I do believe that his wife, who I've spoken with, and if I may just clarify a few things after this point, I do believe she can access somewhat near around $10,000, Your Honor, if there were maybe 100,000, something like that, with a 10% surety.
I'd like $10,000. I would love to have ready access to $10,000. That could be a down payment for a new car because my car's back in the shop. I'm scared though of what they do to have ready access to $10,000.
But before we even go there, Your Honor, I just have to clarify very clearly, the weapons that were seized at the location when the warrant was served were weapons that his wife owned, because the location where the warrant was served was his wife's address. They do not physically live together. So this address where these weapons were found are not additional weapons that Mr. Hardaway in fact purchased or stored or anything like that. Second off, the component of the police entering the home on what they're contending and the wife is contending was a no-knock
You guys
warrant.
see her begging?
No one in that individual home knew that that was the police, which is why, if you understand from Mr. Hardaway's position of, he's a caregiver for his wife. So he takes her to and from, if you see her, she's a paraplegic. I won't get into that. Long story short, he takes her to and from every doctor's appointment. This is a man who would not put his wife's safety at risk and then get up and not have but 2 hours sleep, and bringing her to and from different doctors here and there to deal with the cases that they have right now. So with that said, Your Honor, I would disagree with the obviously the police report says what it says. However, we're very clear that this stems from a larger issue with this MSP officer dating back to something that occurred in Lathrop Village. So I don't want to belabor the point, Your Honor, because this goes to a separate situation, but our contention is that Mr. Hardaway was fired upon, and he fired in retaliation. And so with that said, he hasn't had.
Okay, so he says he's saying he fired in retaliation, but if you shit. Okay. All right. Sorry about that. I thought it died because my computer, this is my husband's laptop, and it doesn't say
Any
when its
interaction
battery is
with the
low.
law as opposed
So
to
I
this
apologize, guys.
felon in possession accusation prior to 2000, back to 2003. Again, I don't want to belabor the point, Your Honor, because this goes to a separate situation, but our contention is that Mr. Hardaway was fired upon and he fired in retaliation. And so with that said, he hasn't had any interaction.
I don't know why I'm having no audio with this.
Felon in possession accusation
Hold on.
prior to 2000, back to 2003. So it's almost 20 years since he's had any type of interaction with them.
Your Honor, just to clarify, Mr. Barton has not had the benefit of getting discovery on this matter yet. I can say definitively that Mr. Hardaway's wife, Carla, flat out saying that she never heard anything.
Okay, I don't know why it's not working. Let's try it again. My iPad is on.
Before the shooting started, she did hear that, yes, indeed, they were there with a warrant, and she demanded to see the warrant. That kind of flies in contrast to the representations that I think have been made to Mr. Barton. Also, it is clear that he did not fire, he was not firing in response to being fired upon. His son has been recorded on body camera telling his father.
Says, however,
we're gonna back it up.
We're very clear that this stems from a larger
all.
issue with this MSP officer dating back to something that occurred.
Sorry, guys, I'm now
Lakewood
recovering
Village.
from a heart attack, and I'm already having a really bad POTS day.
Again, I don't want to belabor the point, Your Honor, because this goes to a separate situation, but our contention is that Mr. Hardaway was fired upon and he fired in retaliation. And so with that said,
Again, a felon has firearms. His attorneys, I just dawned on me, his attorneys actually said that the guns were his wife's, they weren't his. But he was using the guns, not his paraplegic wife. So I am sorry, but that is disingenuous, completely disingenuous.
he hasn't had any interaction with the law as opposed to this felon in possession accusation prior to 2000, back to 2003. So it was almost 20.
You just said that he had the guns, you guys. Dude, you literally just said he had the gun. Come on.
20 years since he's had any type of interaction with them.
Your Honor, just to clarify, Mr. Barton has not had the benefit of getting discovery on this matter yet. I can say definitively that Mr. Hardaway's wife, Carla, flat out, while initially saying that she never heard anything about them being the police, actually did admit that before the shooting started, she did hear that, yes, indeed, they were there with a warrant, and she demanded to see the warrant. That kind of flies in contrast to the representations that I think have been made to Mr. Barton. Also, it is clear that he did not fire, he was not firing in response to being fired upon. His son has been recorded on body camera telling his father that he told him to put the gun down, yet he did not do that. The body cam is clear and all of the camera is clear. This was not in any way, shape, or form a no-knock warrant. There were no fewer than 7 warnings given that I could hear at various points during the entry, even before the door was breached, in addition to statements that were made while they were in there. They were in full uniform that said state police right on the front of it. There could be absolutely no confusion about who was in that house and for what purpose they were there. Besides that,
thank you. Thank you, AP. I do have enough information at this time.
Thank you, sir.
No problem. Obviously, I can just go by with the information that's presented. Both parties have done an excellent job with the information that they have to present their arguments. The court does not take that lightly. The information presented, as well as obviously with the investigative report, the ability to pay. It comes down to obviously my job. I see it as protecting the community and balancing that out, obviously, with a reasonable determined bond if one is required. I do find that a bond is required in this particular case to keep the community safe, to even possibly keep law enforcement safe in this particular case. With that being said, this court is going to issue a high cash bond, in the form of
Normally, I'm not in favor of high cash bonds, but this case I am.
To be the necessary bond for your client to be released. If he is released, he is to be released on GPS tether, and that would be home confinement only. Home confinement only. Given the nature of the bond, I think you already mentioned, Council, is that affordable or unaffordable for your client?
It would be unaffordable, Your Honor.
Okay, there'll be a bond redetermination hearing in 2 days under Judge McConicle. That's going to be on March the 17th at 9 a.m. March the 17th at 9 a.m. for the bond redetermination hearing. Now, also, your client is not to possess, purchase, use any firearms or weapons at any time. He is a convicted felon in the state of Michigan. In the way that the law is written, he is not to be around any weapons, not to possess, purchase, or use any weapons at any time. Mr. Hardaway, do you understand that? I couldn't hear you, Mr. Hardaway. Need an affirmative?
Yes, yes,
all right, thank you. As well, given the nature of these charges, and I believe these are officers or law enforcement, there's a general no contact order with the following individuals: Maxwell Prince, Blaine Stormer, and Michael Thomas. Do you understand what no contact means, sir?
Yes, Your Honor.
Again, I would just advise you probably want to have no contact with any law enforcement official. Move, from here on out as it relates to any of these proceedings. Again, if you are released on that GPS tether. Your next court date after the bond redetermination hearing is March the 22nd in a probable cause conference, March the 29th in a preliminary exam. Again, March 22nd and March 29th in front of Judge Jefferson. If there's nothing further, we're all set on Hardaway.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Counsel. Thank you, APA Penny.
Okay, forgot to unmute myself there. I have one last actually. No, I don't. I have a lot. I have a lot of videos, you guys. Seriously. Let's go with this one. She gets a little I'm trying to figure out how to say this so I don't get flagged by YouTube. They really cracked down on language recently, and I've been getting hit with it. So I think this is the one. We'll see.
Calling case number 230.
Sorry, I'm trying to get these here on my iPad. I swear, I had this all set up this morning. It's gotta be that one then. This is also arraignment court. No, this isn't it either. The heck? You guys, this is crazy. Let me just go back to this one. I'm gonna be a Karen and I'm gonna like file a complaint to StreamYard that their free service their free video streaming services need help. Okay. Go to our Nevada judges. Let's go. I haven't seen there's a couple of these Michael McDonald ones that I have not seen. But they're 1 or 2 minutes. Oh, this is so weird. Okay, we're gonna watch Michael McDonald. Why not? Alex, I hope you're still watching, because here we go. So just so you know, Michael McDonald is the entire reason I really got into watching court videos. His original divorce case.
Council.
It's all on McDonald.
I believe we asked for,
I don't think we sent it to Drew yet.
okay, we'll send it to Drew.
Okay, so we need a confirmation of council. He is set for a petition of writ on June 9th. We want
So literally, like how I do my channel, I'm kind of like our Nevada judges, but I'm also kind of like the other law tubers. I am not quite to this level of professionalism.
Okay, and so
Alex has been trying to get me to do it for a few years now.
Okay,
So
going to be May 19th.
that's where I'm at. I'm half ONJ, half I don't know, but definitely journalism. Not a constitutional law scholar though. I definitely not that, but definitely professional. Let's see here. It looks like that was one of the short ones. By the way, Alex, if you're here, I'll have to text you, but you don't have a McDonald versus Warden playlist. I don't know if you're aware.
Judge, we're gonna go with page 2, McDonald.
McDonald, 832-506. This is on for appointment of counsel, and Ms. Lemke is accepting. Oh, sorry, yes. Well, I thought fully vaccinated, you know.
I am, I'm going to accept the appointment, Your Honor, and if I can ask a couple questions of the court. I believe this case has an A number, which tells me that the defendant, Mr. McDonald, has already filed some kind of pro per petition. Is that correct?
So this is back from May?
Yeah, I believe.
Of
yes,
last year.
Okay. That just makes a difference for timing purposes with my initial filings. And who represented him in his prior proceedings?
Yeah, Mr. Mueller.
Okay. I would suggest maybe like a 45-day status check for me to track down the file from Mr. Mueller and hopefully have a chance to review it. And then maybe we could set a briefing schedule at that point.
That's fine. 45 days.
Okay, 45 days is going to be, you want it a little longer or a little earlier? Because 45 days is when we'll be dark.
Oh, longer would be preferable. Thank you.
Okay, we'll go to July 7th, and that'll be do you want it at 11 o'clock? Is the defendant going to be here?
They usually are not present for these kind of routine proceedings. I think to the extent that it proceeds to a full hearing, then he would be present for that, but we can do it without him.
Then we'll set it for 12:30.
Okay.
For this hearing. It's for the out of custodies, but it'll give more time for the in custodies.
Perfect. So July 7th at 12:30.
Yes.
I
Okay.
have really no basis, but I wanted to say he should be out. But can anybody see that from the?
So yeah, Mike McDonald was still in prison at this point.
He
I
got,
think
let's see now.
he was given his parole
Okay,
just a
so
couple months
maybe
later.
the JOC.
I don't even think he's been out 6 months yet. I kind of lost track of all that stuff because I don't really
No.
follow it like I used
All
to.
right. 45 days. We'll talk to you then.
July 7th.
Your Honor, and thank you for calling me out of order. I appreciate it.
That's no problem. All right.
Okay. Now this is July 7th.
Correct?
Yes, sir.
All right, we'll pass it 2 weeks to, then we'll set a briefing schedule.
Okay, is the state here? Who's the state?
Thank you, Your Honor. I appreciate.
Who's here on behalf of the
Morgan
state?
Thomas.
Morgan Thomas, Your Honor.
All right,
And the 2 weeks is going to be July 21st at 12:30.
Thank you so much, Your Honor. I do appreciate it.
thank you.
Excuse me, what case was that?
What was
Seven.
the time again? I'm sorry.
Excuse me, what was the name of that case?
What was the time of the?
Who's talking?
This is Adam Honey from the Attorney General's office. I'm here for a status check as well, but I don't know what case it is.
That was Michael.
Page 7 doesn't. Okay, thank
No,
you. I'm
different
here on
case.
Felton Matthews.
Different case.
Yep, sorry to interrupt, Your Honor.
Was that not Ben Bateman?
All right, let's do page 3 because we have an interpreter here.
The heck? I don't know what just happened. Okay. So now this is the July 21st hearing.
Michael McDonald. This is to set a briefing schedule. I see Ms. Lemke.
Good afternoon, Your Honor. Nancy Lemke appearing on behalf of Mr. McDonald.
Okay, you guys, I don't know what is going on. I have multiple videos playing at once. This is so strange. No, I am seriously having technical issues right now. Ugh. The hell? Okay. Ugh, come on. I am having some major technical difficulties right now. I don't know how. I don't know what just happened. Possessed or something. All right. So now we have Michael McDonald versus the Warden on July 21st of 2021.
Okay, and then, what, 30 days for a reply?
That would be great, Your Honor.
30 days, and make it 30 days after that for the hearing.
Okay,
Well,
90
2
days?
weeks, anywhere, 2 weeks to, yeah. After
Okay.
that for the hearing, something like that.
Okay.
I don't know, what month does that get us into?
Well, we're looking at next year. October 18th is 90 days. So that's for the supplemental brief. The opposition would be November, we'll make that November 29th. And then the reply would be, do you mind if it's during the Christmas holiday, is December 27th.
That's a good question. It's possible that I'm out of town, but that's fine. I should be able to get it done before I leave. So that's fine.
Okay, December 27th, and then we can do the hearing in January. We'll do January 12th, 2022, and that'll be at 9 a.m. currently set.
Yeah, make it
You
the
may
week
have to.
after. We're always swamped the first couple weeks of January, so make it.
Well, we have that holiday that's going to delay us too, then the following week, it'll build up. But we can do the 19th or the 26th.
Okay, this is boring. We're gonna go to the next one, which is the January
Whatever the
January
court's
one.
pleasure
The
is. Let me
26th.
double check.
Yep. Michael McDonald
Yes, Your Honor, Nancy Lemke on behalf of Mr. McDonald. He should be here.
is right behind you.
Well, look at you over there. I didn't see you come in.
Now his attorney does not want him to talk. Does not want him to. Oh my gosh, this is where it kind of gets a little funny.
Who's here for the state?
Good morning, Your Honor. Karen Mishler on behalf of the state.
Oh.
All right, so I've read all of this, and although defense counsel raised legal issues, the defendant in his petition raised a lot of factual issues regarding his former attorney. And although you alluded to some of them, and I'm talking about defense counsel, alluded to some of them, you didn't really repeat them in your supplement. Some of them, and I'll let you guys argue on this, but I certainly assume that as far as his pro se, you're requesting a evidentiary hearing.
Well, as to his pro se, to the extent I guess that's necessary with the pro se pleading, quite frankly, Your Honor, I was more focused, although I did incorporate by reference in my supplemental petition the arguments that were advanced by my client pro per in his initial petition.
Right.
What I'm really focused on and ready to address this morning or this afternoon, I guess I should say, are the arguments advanced in the supplemental petition, because I think that's really where a lot of the critical issues lie. And to that end, I may need to put Mr. McDonald on to fill in a few factual gaps on, I think, maybe 3 of the arguments that I raised in the supplemental petition. And
well, the reason, let me stop you. I cannot ignore unless he waives or withdraws his petition. I can't ignore all of his claims, which means, and certainly the state has argued that several of them are, as the Supreme Court has said, I forget their language, but basically that they're bare naked allegations in any event, but
I'm gonna give you guys a trigger warning. If
there
you
could
can't
be
stand
an
watching real
issue
people
on
eat
some
food,
of them,
I'm gonna
which
have
would
to
require,
stick because
first of all, would
I'm hungry.
require Mr. McDonald to waive his right regarding attorney-client privilege and bringing in Mr. Mueller. So tell me why I don't see how we can go forward at this point without considering, again, unless he wants to withdraw his entire, his allegations, we need to do that.
Why don't, to the extent that that the court is concerned with that, maybe if you would give me a few minutes to discuss that with Mr. McDonald, and you can recall the matter closer to the end of the calendar, and then I can determine with him whether or not he wants to move forward with those.
Okay. All right. I'll call it at the end. What else?
Page 7, McDonald, Michael.
Oh, did I? 832-506. And
yes, I know my dogs are very, very spoiled.
go ahead and state your appearance again.
Thank you, Your Honor. Nancy Lemke on behalf of Mr. McDonald, who is present, and he's technically, I guess, at liberty, but he is being housed at Casa Grande pursuant to this court's earlier sentence. So I don't know if that makes him present out of custody or technically in.
And Karen Mishler on behalf of the state, Your Honor.
Okay, so just to continue, because the defendant made several claims of ineffective assistance that were based on factual issues, he needs to waive his right to attorney-client privilege if he's going to.
So, actually, you know what? Let me, gotta send a link. I gotta remember how to do this. Okay. I am trying to get a link to Alex so he can get on and explain this, but I'm gonna let this play. One of the things Michael McDonald started doing pretty quickly was saying that Craig Mueller was not effective counsel. So that's where he's basing
Proceed
this
on
off of.
those, and we need to set a hearing. What did you decide?
Yeah, so Your Honor, he is prepared to waive attorney-client privilege to the extent that it's necessary to flesh out some of the factual issues. We are prepared to proceed today. It is our position that that Mr. McDonald can testify to what factual issues need to be kind of clarified in terms of the issues that have been raised. Everything else in terms of what wasn't done by trial counsel, we have adequately asserted those in both his initial poker petition and our successive supplemental filing. If the state wanted to argue that there were strategic decisions that resulted in some of the deficiencies that we have outlined, then that would be their burden to proffer some evidence to support that. I think they're going to struggle because I have interviewed the one witness who could testify to that. And I think they're going to have a hard time with that. Nonetheless, they've made representations in their responsive pleading that there were strategic decisions made. I would suggest to the court if they want to put on evidence to that effect, they would need to do it. But we are prepared to proceed today with what we have and Mr. McDonald's testimony.
I understand, but somebody pointed out. Go ahead.
Sorry, Your Honor, but just to be clear, in any evidentiary hearing on a habeas petition, it's the petitioner's responsibility and burden to demonstrate their claims by a preponderance of the evidence, and it is actually a petitioner's responsibility when they raise ineffective assistance of counsel claims to call prior trial counsel. It's not the state's responsibility to do that. Additionally, this was not set for an evidentiary hearing for today, so the state would definitely object to going forward on an evidentiary hearing on this.
Well, just to respond, that's false. I mean, we raised the claims, we make the arguments that there were deficiencies that occurred. If the state wants to argue that there were strategic decisions that the deficiencies were the product of, it's their burden to respond and proffer testimony through trial counsel that indeed trial counsel failed to do certain things because there was a strategic determination made not to do them. That's how it works. We have raised the issues that relate to trial counsel's inadequacies to the extent that there is additional information that is needed for the court to hear from Mr. McDonald on certain of those claims, then we would present that testimony, and we are prepared to do so today. So with that in mind, I would submit the question of whether or not there should be a hearing today or not to the court, understanding that we're ready to go forward today.
All right, well, I've, not that it's dispositive, but it's always been the petitioner who has brought counsel in. But either way, and certainly, but the point is, we do need to have an evidentiary hearing, and I don't want to, as somebody had said while we were doing all this waiting, I don't want to break it up. I think we should certainly, I'm hopeful, get it done in an hour or maybe something to that effect. But in any event, I want to do it all at one time. Mr. McDonald is asserting those claims, and he is going to, and I want to ask him on the record whether he's going to waive his right to attorney-client privilege for those issues to be brought up. But I'm going to set a time when we can do this separate and apart from the fact that I've now been in here for 3 hours plus without a break, and that goes more importantly for the staff.
A judge had to work all of that 3 hours straight
at one time.
I get the staff.
So
I'm sorry, that comment always irritated me.
Have my JEA set up a time when we can do that. Mr. McDonald, on the issues that you've raised regarding ineffective assistance of counsel, are you going to waive your attorney-client privilege regarding those issues?
Yes, Judge.
All right. So I'll have my JEA notify everybody when we can coordinate this. And now with Omicron, et cetera, I don't care who, well, I would agree that under the case law, the petitioner has the burden of proof, but as if the state wants to bring in Mr. Mueller, or whether the petitioner does, I certainly don't care. Mr. McDonald will testify. How long do you expect that to take?
I would say probably at most 20 or 30 minutes.
Okay, and then certainly him, and then
hopefully much less than that, Your Honor.
Okay, so again,
She doesn't know her client very well.
Like that. The briefing was extensive on both sides, so it's I'm only going to have limited argument on that. So I will have my JEA's out sick, but when she's back, We will schedule that. All right. Anything else?
Your Honor.
Okay, you guys, I have brought a friend.
It just came to my attention recently.
Let's see. Okay, hey Alex.
Hey, can you hear me?
I can hear ya. You're a little quiet, but I can hear you. I haven't talked to you in, I don't know, 10 minutes.
Hey, can you hear me better now?
Yes, I can hear you better now. Okay, so you explained to me, because ultimately Judge Israel denies your motion in part to broadcast. It's really complex. I don't remember it. I have ADHD. We all know that. You still there?
Yeah, I'm here. I'm trying to switch my camera over.
Don't worry. I've had all sorts of technical difficulties today. Oh my gosh. Everyone got to see my, well, I don't have an overly large derriere, but my voluptuous body run. Because I thought the computer died again. Oh, okay. So ultimately, and it's not in this hearing, it's at the next date, he does deny your motion. But then, did you appealed it next? Is that what was next?
No. No, we actually submit. So it's not done by motion. It's done by this one-page piece of paper. And it was like 6 months in advance, and he granted it. So what happened was Craig Mueller and the public defender showed up and claimed they had no idea. Craig Mueller, that's believable because he's just a witness. But the public defender, that was the most ridiculous thing I've ever heard. Those notices are sent from the court. So she knew 6 months in advance, and she complained to the court that she had no idea. And I guess, one of the things that sucks is they had this discussion outside of the courtroom. So we really don't know if it was Judge Israel that they were talking to in chambers or if they were just in the hallway. It was a pretty lengthy discussion, but whatever they discussed out there must have been the real reason for why they did not want this case to go, to be covered electronically. And I say that for two reasons. So apparently you have these videos pulled up. You could just show them so they could see. I mean, maybe after I leave, but he claims like attorney-client privilege and confidential stuff, and like I guess Mike was gonna like talk about the inner workings of his office. But if all of that was true, the transcripts wouldn't have even been available. And not only were the transcripts made available, but the JAVs was available. And for people who've been watching our Nevada judges, they would have probably seen other hearings where this attorney-client privilege stuff actually comes up. And when that actually comes up, they removed the prosecutor from the courtroom. So as soon as I heard that Judge Israel was saying that there might be attorney-client stuff, and he did not remove the prosecutor from the courtroom, it was such a punch to the gut because I knew he was violating the law on purpose, which is something that we've seen before with other judges, but the cases are usually, they're very low profile. And so you guys don't really hear this kind of stuff. The problem is that this time, Judge Israel did this on Michael McDonald's case, which is one of our top cases, and he did it live. So we actually usually the judges will do something really weird that we don't have on camera, like they won't open the courtroom door, or they will say that we can record, but they won't let us set up. They'll just kind of play.
So sort of like going back to like Las Vegas, Steve Sanson and Veterans in Politics, they were literally walking around the courthouse and seeing like they were supposed to be having hearings, and the doors were locked to the courtrooms. So similar to that, essentially.
There's certain judges just don't want a lot of people to see what's going on in the courtroom. They're okay. They're okay with like a small number of people seeing, but if it's like 100 or 1,000 or 10,000, that's certain judges do not like that. But they can't say that. They can't just like say, you can't be in here because too many people will be watching me. They'll have to cook up some kind of nonsensical reason. But in this particular reason, it was super disappointing because it was one of our top cases. There were so many people that wanted to see it, and he was just very dishonest about it.
Yeah.
So, I mean, all of the reasons that Judge Israel says we could not cover that case were complete nonsense because we still got the jabs anyway, and we still published it. So all of the information came out anyway.
Yeah. So how is it? Because did you have to file something?
Yeah.
Or how did that happen, or what was that process?
So that's called a media request. We call it that shorthand. It's actually called a media request for electronic coverage.
Mm-hmm.
And he got that 6 months in advance. Like, if this was seriously, if this was seriously an issue, then the chief deputy public defender, I think her name was Nancy Lemke, she could have filed an objection within even a month of that, and then we could have dealt with it accordingly. And then if we were denied, we could have filed an appeal. Well, it's not called an appeal, it's called a petition for writ of mandamus with the Supreme Court, and they could have given 2 or 3 months of thought. I mean, there was so much advanced time, but instead
Supreme Courts move so incredibly slow.
Well, it's one of the things that I've noticed, that when an attorney knows they don't have a good reason to block camera access, one of the strategies that they will use is they'll file the objection right before the hearing. And I've seen 2 lawyers do this. The first is Todd Matthew Phillips. He's done it twice. In fact, he got chewed out by Judge Maria Gall because he had like such a long time to object, and he waited till like the night before or something like that. So she chewed him out on camera.
And with my case, when he sued me, he actually was filing those motions late.
Well, but those situations are different because with you, if somebody files something late, you still have a due process right to respond. So, like, typically what the judge would do
so he would file his response or an objection to something late.
Okay, well, no, that's not okay. So this wasn't technically late. What it was is it was strategic.
Okay.
And so he's not the only one. I don't want to just put his name out there. Another
lawyer
I've seen do this was his name was Kurt Harris. He waits.
That's right. Yep.
He waits until like the weekend to file it. He files his objection like on Saturday or something. But this is something that they do, is they just don't have a good basis to object. So they wait until the last minute and they cross their fingers and they hope they'll have a judge that doesn't like cameras. And in this particular case, it worked. So Israel waits until the day of, he abuses his discretion on purpose, and then we don't have a remedy. So like we don't have a way that we can get the Supreme Court to intervene in time. I mean, the perfect example of this is our appeal that our en banc oral arguments, which we covered on March 2nd. That particular case, we were denied camera access by Judge Hoskin, and we filed our writ petition as quickly as we possibly could. And the Supreme Court said in their order, we don't have time to review this, sorry, but we will consider it with what they call the mootness exception. So even though they will eventually consider it, we've already lost the opportunity to get that hearing covered. So it's disappointing because judges shouldn't be acting, like politicians, but that's the kind of games that we see when it comes to objecting to camera access. Is we see these weird things that they do to sort of frustrate our ability to get the Supreme Court's attention. And that's what Judge Israel did. That's what was so disgraceful about it. But if you get a chance, I hope you show your viewers, I mean, the what he does, because I want them to see that, like, here's all of these concerns he says are an issue, and then we end up getting the Jabs video and publishing it anyway. So all the information still comes out.
All the Jabs videos are like 1 or 2 minutes. They're real short. And I had said, you probably didn't hear it, there's not a playlist for McDonald versus the Warden.
No, there is. It's just lumped into the 2 original cases because those those Warden cases are connected to the
I got you.
Yeah.
Okay, well then that's my fault for error. Now, so you have someone like you where you actually go into the courtroom or you join the Zoom meeting for these hearings. But then you have law tubers like me where I'm relying on the fact that the courts have they broadcast the court cases over the internet. I am not anywhere close to being able to do coverage like you do. I hope to. That would be really, really awesome. But now we've talked about the whole Fiona Apple thing. So Criminal, Fiona Apple, that's her song. That was the first song I remember. Shadowboxer, Criminal, whatever. So she's in Massachusetts, but they like have basically shut her down by denying like all court watcher video streaming access. Like, right?
Well, my understanding is that they completely ruined it. So let me just I don't have 100% knowledge of what's going on there, but I have about 50% knowledge. So you can't really double check on everything. But my understanding is that she and her court watchers, this is just based on what I've read. I don't know if this is for sure. My understanding is that she and her court watchers were able to get somebody who was wrongfully convicted. They were able to get that particular person either removed from jail or exonerated or complete. I don't know if he was found actually innocent, but the court watchers that she had discovered some information through their watching that they provided to, I guess, his legal team. I don't know if it was the Innocent Project or who, and they used that information and they successfully helped this guy who was wrongfully convicted get out of prison or jail or whatever. Apparently, now this is also an allegation from Fiona Apple's side. The state got really mad at that, and they decided that the way to solve the problem was to just cut off the court watchers. And the way that they, again, this is an allegation, the way that they did that was they changed the rules and shut down all of the virtual hearings or most of the virtual hearings or something like that. Apparently, there was a power struggle for a short while, and the compromise that they didn't really come to, that was just sort of forced upon them, was that they were going to have audio only, and the audio quality is garbage.
Yeah,
this is
essentially they're trying to stop it by being jerks.
Well, the thing that people have to understand is that anytime you're trying to change a system, if it's going to cause people to lose influence or to lose money, two things that are often interconnected, you're going to encounter resistance. Yep. Even if you're doing something that's beneficial for the public, that's beneficial for the citizens, that's good for the country, that's educating, those things do not matter. You will encounter resistance. I've lived this for the past several years. So doing something that's actually helpful is one thing, but if it's going to impact, if it's going to disrupt industries, you're going to encounter political resistance like this, and that's exactly what they're encountering.
Yeah,
it's a problem with the way that, I guess, I don't know what to call it, sort of the ruthless approach of the sort of win at all cost mentality that attorneys have, most attorneys have. And I mean, all costs includes things that aren't fair. And I really do believe that it's not a fair thing to do. If regular people want to learn about the court system, let them learn about the court system. That's that's a no-brainer to me.
That's what it's been for me. I was decades ago now I worked with, started with the local police department, but moved to the county as a domestic violence advocate, and then I became an investigator advocate. So I had connection with the court, and I was also an EMT paramedic back then. So that was kind of my connection to the courts, and I knew all of like the Michigan domestic violence laws. I knew that stuff. I was helping train officers and other agencies, because they had FBI bubble sheets to fill out, all this stuff. So I had that, I had that connection. I have that knowledge, but I didn't do that for a long time after my accident. I kind of just, my whole life was upended. But now, like, I still enjoy true crime court stuff. So I was watching it anyways, and I was watching it at work, and I found a couple of the law tubers, and I started watching their stuff. Then I found that, hey, there's these other Michigan judges. So I started watching. My favorite is Judge Simpson out of Washtenaw County. And watching him in the different cases that he had, I've honestly learned so much. Like that, and we're talking about older laws, but I've learned a lot. Like watching him, and I know other people have learned. Like if I for whatever reason, knock on wood, I've never gotten a ticket or anything like that. Like if I were to get pulled over and like, oh no, my speedometer is broke, whatever the excuse was, now I know how to go about and try to fight the ticket. Other than what it was is you ask for a hearing and show up, the cop doesn't show up, it's dismissed. That's still how it goes. But now even if the cop showed up, like I have a better idea of how I would kind of deal with that. And honestly, with the lawsuit that I had against me, I still didn't know a lot about the courts and the law, but I had more knowledge, and I'm still gaining knowledge every day. And that's part of what I do is I want to help educate. I want to shine a spotlight on good judges and good lawyers and good cops. And I know there's bad ones out there, but you can turn on the news every day and you find all the bad. We don't have the good stuff anymore. So I like highlighting that stuff. And I want to educate. But Michigan is sort of, we have judges that as soon as they could stop doing Zoom, they stopped. They haven't been on for a year. But then we have other judges that are like excited about getting better audio system, better camera systems. And they're very enthusiastic about having public access and watching these cases. But then we also have folks that are literally just for money.
Well, that's something that I've noticed with Nevada too, is that you have some judges that are there for the paycheck. You have some judges that are there to actually educate the public, that are excited about justice. I mean, I think this is something that a lot of people don't understand. I think a lot of ordinary people just assume that every single judge on the bench is like Gandalf the Grey. And that level of wisdom is actually something that I even rarely see. I mean, I see that coming from our Supreme Court, but I would probably only see that coming from like 15-20% of the district court bench. And it gets worse the lower you go, which is quite sad, because the lower you go, the more of the ordinary people that interact with that particular court system. So municipal court, family court, that's where most people are going to end up. And that's where the lower quality judges are going to be. It's something that I've noticed. It's something that's disappointing, but I don't want to be dishonest about that. Judge Judy's had a couple of interviews on this problem. A lot of people think she's just a TV judge and she's a joke. She was a real judge for a while. She was a real judge.
So was, what's his name? And he was originally from Detroit. There was a judge that literally, she was in his courtroom. She has his old courtroom. I think it was Judge Bryant. But Greg Brown? I forgot. He became a TV judge too. But yeah, they are real judges.
Well, the thing that I didn't really understand is that the for some reason, and I didn't believe it until I saw the interview on Norm Macdonald with Judge Judy. For some reason, the camera seems to be the kryptonite of the incompetent judge. They're just absolutely terrified of it.
Well, just like the cops that don't want body-worn cameras and all that stuff, and they don't want people getting access to the footage because they know that it's not going to look good for them.
Well, they know, I think part of it is that they're going to look bad in front of the public, but that's not really most of it. I think most of it is that they're going to look bad in front of other professionals who would not have otherwise known, that will then begin to undermine them. And there are very powerful people who do care about this country who just don't really know much about the legal system. And those are the people that when they see this footage and they start to have concerns, they start to pull strings behind the scenes to get rid of some of these, incompetent judges. And I hate to use that word, because whenever I use that word, I sometimes make it seem like they're all that way.
Yeah,
I don't think
and they're not.
That way. It's just that they are there and that they are a problem.
Yeah.
But that's really what it comes down to is right now you have a system that really isn't used to this kind of virtual coverage. And you have the COVID and the COVID-19 restrictions and virtual court showing people a new way to access the court system. And now there are doubts there that maybe this notion of cameras and virtual access isn't really as bad of a thing as it's going to be. We were all going to court. People were covering hearings on YouTube, and the sky did not fall. The planet did not implode. Everything was fine. And it's very concerning, I think, to the people who are used to things being the way that they were before, because they're starting to see that the public has more influence than they used to have. And if there's more influence somewhere else, now they have to compete with that.
Yes.
It's not really as much of a problem, I think, in most states. I guess Maryland lost their mind when that person got released. But it is a problem in certain areas where they just aren't used to sharing power, sharing influence, which is family court, guardianship and probate cases, stuff where the media just rarely goes.
Yeah.
So this is something that people are going to start to notice, is there's going to be a power struggle in all of these different jurisdictions over the judges who want the public to see what they're doing versus the judges who don't. And you're going to start seeing some jurisdictions go dark. You are.
Yeah.
So
I'm not a fan of that.
Yeah.
Yeah. So what would, like, I'm not you. I'm not our Nevada judges. I'm not our Michigan judges. I know we're close to that. What would someone like me or, you know, our viewers, how would they kind of help?
I can't complain.
Sorry, Siri's talking to me. You know, what are things that we can do to try and, like, foster this positivity and, like, proving that the courts are good, I guess. Like, if courts start shutting down, you know, how can we actually do anything?
Well, what you're doing now and discussing it is what I would encourage to continue to occur. I think that people need to just be aware of it. Because when the opponents to transparency start to argue against it, they're not going to go on, you know, TV or go before legislatures and say that we don't want stuff on virtual, you know, court, because then the public is going to know everything that's going on and they're going to be educated and amazing. They're going to say things like victims are going to get exposed or people don't want to have their faces. They're going to use stuff like that.
Yeah.
And I think that the more discussion that there is on how victims are protected, whether victims are the ones that are asking for these cameras to be shut off or whether it's lawyers that are stealing their voices, which we just had an example of in Nevada.
Yeah.
You know, people just need to be aware that these arguments are going to be asserted and they need to be challenged. And so the more you talk about it, I think the more that that's likely to occur. But there's a list of common tactics that the opponents of transparency use. And it often comes in the form of privacy arguments, which I think is the most outrageous notion. I mean, for me, privacy is like birth date, social security number, address, phone number, bank account numbers. Privacy, I mean, like, you've got paparazzis that follow people around and take photos. Like, that's obnoxious, but come on. The courtroom.
Just the other day, I was leaving a doctor's appointment, and I have an ex that's a little weird, and apparently so is his partner, and she literally was trying to run me off the road, but there was no running me over, only into oncoming traffic. And I mean, it was bad. We were going over at 1.85 miles an hour on the highway, and she drove like she knew where I lived, apparently, because she was getting off the exit, but she didn't see the state trooper that popped up behind me and pulled her over. I boxed her in so she had to continue getting off. And what's funny is where she's getting off is my exit, but I also live kitty corner to state police headquarters.
Okay.
So, but I mean, there are people that are crazy like that. For me personally, when I'm doing videos and I've had complaints about it, I do remove the names and addresses and phone numbers and, like, contact information, even of the people that are, you know, the defendants. You know, they don't, as you know, I've heard judges say it, you know, once that information's out there, it's out there. I'm not going to be a party to allowing continued harassment years down the road. You know, because my channel's going to be here for however long, you know, for eternity. I'm not going to make it easier for people to get information. Because I know, there are people that have to be getting emails or phone calls from crazy people because it was on YouTube. So, like, I understand when judges talk about privacy issues with that. And I think as a creator and you even called me a journalist, which is kind of odd for me, thinking of myself in that role. But I do protect that information, because I put myself in their shoes. If that was me, would I want my information to be recorded and not edited out? No, I wouldn't. I'm very conscientious about that, and I know others don't care. I hope that there's maybe some sort of a shift where folks start taking a little bit of more accountability for what they're doing.
Well, I mean, that's one of the arguments that's going to be used against the camera access stuff, is that certain channels aren't dealing with it appropriately. And I think that's why in Nevada we have the media request, and that's why the judge has the discretion to deny it for unprofessional or even non-news reporters. There may just, if it's a channel that's just making fun of people, I mean, they're probably not going to get news reporter status.
Yeah.
But you know what? You have to realize, like, privacy is not just like the end all be all. Like, there are other things that have to be considered. It's a balancing test. Like, on the one hand, you can have extreme privacy that's harmful to the country, and you can have extreme transparency that's harmful.
Yeah.
So like, it's not so simple as just saying this person doesn't want their information out there. Like, that has to be weighed against all of these other issues. That's why we have the First Amendment. It's a very, you know, one of the things that we talk about with the First Amendment that is frustrating is most citizens appreciate it, and they think it's the most important thing that we have because it is the First Amendment, number one.
Yeah.
But when you ask them if they personally would want to be on the other end of it, most of them say no. So this is why these amendments are so important, is because they're very, I feel like it's very counterintuitive, then that people's instincts will push them in the wrong direction very easily, which is why they have to be articulated in the Constitution to sort of keep the country on the right track, even though it's uncomfortable sometimes, even though people get hurt sometimes. I mean, look at the Second Amendment. The Second Amendment hurts people all the time. There was the DCB Heller case had something in there from one of the dissents that said 144 kids are shot with guns every year. I mean, this like the amendments do cause harm, and they're still there. The First Amendment hopefully doesn't get as many people killed as bullets being shot. It still causes some harm, and there still has to be some kind like this. These are difficult things that we have in this country that are discussed, that are enshrined in the Constitution because they're so controversial and because they're so complicated. I think if it was something really simple, it wouldn't even have to be in the Constitution. People would just get it.
Yeah, and like I think people don't understand that the reason they had to write the Constitution the way they did was so that we literally did not become Great Britain.
Yeah, I mean, I was
breaking away from.
I was kind of surprised to see that the list of amendments to the Constitution was just like a list of complaints. I thought that they were more like philosophical, but apparently if you go through them from at least the original ones, people were just like, hey, but the Crown used to do this. Okay, we'll put that in there. Hey, but the Crown used to do that. Okay, we'll put that in there. Like
the taxation without representation.
They like listed all of their beefs and like tacked them on. That's like, so I mean, and I feel like another thing, and I guess this is kind of the same thing, but saying it in a different way, is that the Constitution represents the things that the legislature and apparently now the judiciary cannot be trusted to legislate and promulgate on their own. Because if they could be trusted to do this on their own, then they wouldn't have to be restrained, which is really what the Constitution is. It's a restraint. It basically
against the government.
It is. It basically says that if you make laws that do these particular things, then they're invalid, which is a pretty weird, I mean, if you think about it.
Way to start a country?
It's pretty weird if you think about it, that the people who are making the rules would need rules to tell them what rules they can't make. It's a very odd sort of thought. But I mean, we see that all the time. Is that when it comes to the issues of transparencies and firearms and all these other issues that are in the Constitution, search and seizure, that they make these rules that are self-serving, that benefit the wealthy, that benefit the legislature, that benefit the judiciary even. It makes let's talk about JCRCP 106. So that was a court rule that the justices of the peace decided would be an amazing idea, which is that you cannot appeal a summary eviction order. They made that into a court rule. So that means the legislature didn't get together and do that. The executive branch didn't do that. The judges themselves got together and decided you can't appeal summary evictions anymore. And they put that into a court rule. And they themselves violated the Constitution. The Supreme Court of Nevada approved it. And then somebody ended up fighting it. I think it was the legal aid centers, took it to the Supreme Court's attention. I might be wrong about that. Somebody did take it to their attention, though, and they did strike down their own rule. So get your head around that. Get your head around that. A big body of judges got together and said, you cannot appeal summary eviction actions. The Supreme Court said, that sounds great, and stamped it, approved it. And then a bunch of lawyers had to tell the Supreme Court that they violated the Constitution. Right. And the Supreme Court said, oops, we screwed up in their own.
We did it again.
The Supreme Court of Nevada, I think it was a Lippis v. Peters case, said that we ill-advisedly approved this rule. It's unconstitutional. Sorry, and struck down their own rule. Like, this is the kind of stuff that happens. There's judicial bodies, legislative bodies, executive branch, and they can't be trusted to make rules.
Well, and they can't, I mean, really the way it's set up is they can't make rules about the other branches. They all oversee their own self.
Yeah.
This is
the stuff that I think a lot of people need to see that's going on, is that everything is not going perfectly well. I think for the most part, there's a lot of lawyers and judges that are trying to do the right thing, but there's also malefactors. There's also people that are exploiting the fact that the public is not paying attention. There's serious issues going on. And I think that the more the public is involved, the better it gets. That's what I've seen for the past few years, is that the more the public is aware, the more things get better. I mean, you can't deny.
We can't know, and we won't know that changes need to happen if we don't know about what's going on.
Right.
At the bottom line to all of that. So hopefully I can make, I don't know, some sort of a difference here in Michigan. Like I said, we don't really have any rules. I mean, the Supreme Court said set these guidelines with COVID, but we're kind of out of COVID now. So, but there's still no rules. And, you know, for me, I don't know what to do. And I'm like, you know, we've talked about that as far as like, I don't know what I'm doing.
Everybody has a small role to play. You're part of probably another 100 or another 1,000 YouTubers that are, all of your efforts are adding up, you know?
Yeah.
We're very lucky that the Supreme Court here in Nevada is taking it seriously. The virtual access issue is before a commission.
Yeah.
They formed a commission to make some court rules to make virtual access a permanent thing here, or at least to consider it. I don't know. I'm not sure what it will look like when it's finally done. The gist of both sides of it are that it's okay for virtual appearances to be at non-evidentiary hearings, but that they want in-person appearances at evidentiary hearings and trials, which actually makes sense to me. But that's not with regards to observers. That's just with regards to like the attorneys and witnesses and stuff. And then they have the amazing camera access rules in Nevada, which is something that I give the Supreme Court compliments and credit for anytime that I can. The rules that allow camera access in Nevada are amazing. They create a presumption for an ordinary person who is not a lawyer. This is what the rule says. If you don't want a camera in a public courtroom, we don't care. Screw you with the camera in there anyway. I mean, I'm oversimplifying it, but that is a powerful, powerful rule that has made our Nevada is able to do what it's doing. So
yes. And hopefully there's others that are out there that are like you and me that want the transparency in the courts. We want access to the courts so people can know what's going on. Mm-hmm. I mean, when we get, it's not a law, but it becomes a rule based on other hearings or rulings, whatever. Sorry, I'm having a bad ADHD day. I can't remember what that's called. They call it a something rule. It's not based on law, but it's still kind of become the law because of rulings. Precedents. Yeah. There's precedent-setting cases. And I don't think people realize precedent-setting cases aren't necessarily going to be the big flashy cases that you're going to have on like the Law and Crime Network, A&E, that Dan Abrams. Those they're not necessarily going to have some of those really important precedent-setting cases because they come from small, like it'll be littler things, you know, like rules about family court. You know, when cases become precedent-setting for family court, that's not going to be covered by large media corporations. It's not necessarily sensational cases. It can be very dry and boring. And I understand that because I watch all these cases, but they're important cases. And these are the cases that the public needs access to. I mean, yes, the sob sits and people screaming and crying, that's fun and that's entertaining. But there's more, there are very important cases that are also happening and they're not quite as fun.
Yeah,
But
well, they're tabloid cases. That's how the judges see those. The judges see those as those silk-sit channels as tabloid channels. They have no respect for them. So, I mean, it's funny to point and laugh, and you're going to get a lot of money, but you're not going to get any points with the judiciary, legislature, and they're just going to use those channels as examples as to why they should shut down virtual access. That's what they're going to do. It's basically ammunition for the opponents of transparency, and they don't even realize it. Or maybe they do and they don't care.
They just don't care. They want money.
Right.
Yeah. So
well, I got to get going. I got a work meeting, but it was fun.
All right. Yeah, we'll have to definitely get together again here on YouTube and talk about other court stuff. This is very fun. I enjoy your channel. You know that. I've supported you guys from the beginning. I am going to go play some more Our Nevada Judges videos that are very fun and sort of exploitative.
Okay.
Okay, you have a good one. Talk to you later. Okay, and on that note, let's see here. We are going to get to... I don't want that video. I don't know. I said no. What happened last time is somehow the screen, like my two internet screens split. It was so weird. Let me get... I am going to pull up. Let's see here. Go back. Sorry, I don't wear my contacts very often, especially in the spring because of my allergies. So it's kind of weird wearing them again. And then I'm just getting older and I need to use reading glasses. Actually, I had a very sweet woman, Debbie, the other day, made a comment because I said something about in the past or whatever. And she's like, what are you, 20, 30? You guys, I'm going to be 42 in 3 weeks. I know I don't look it. It's my year. 42 has been my number for a very long time. It was my best friend's football jersey number. He passed away in high school. So 42 has kind of been my number. I was literally told by almost every physician I've ever had until adulthood, like I was not going to survive that long. I was not expected to survive childhood just because of the health stuff. So there we go. I found it. That's the channel. Okay. Hang on. I found the channel, but no, we're gonna go. Okay. Let's see. Gotta share this screen real quick for you guys. This. Okay. Now, this is, we talked about Todd Matthew Phillips, TMP. This is his case against Jennifer Abrams.
Going to move on. Next up happens to be page 14 of the calendar. T. Phillips versus Jennifer Abrams. Let's go ahead and set forth our appearances for the record.
Adam Pernsteiner on behalf of defendants Dave Schoen and Mark DeCero, Your Honor.
Good morning.
Good morning.
Good morning, Your Honor. Lisa Zastro for Jennifer Abrams and her firm.
All right, good morning.
Oh, if anyone wonders,
good morning, Your Honor.
I have a
Initial
that I'm
T
following
period
from
Matthew Phillips presented. Hello.
Is that you, Mr. Phillips?
Yes, Judge, it is.
Okay, we couldn't hear you, sir. but you can go ahead and set forth your appearance again for the record.
The name is initial T period Matthew Phillips, and I am appearing today in propria persona.
Okay. All right, sir. Good morning to you. And let's continue on.
Adam Matthew Phillips is a licensed attorney in the state of California.
All right.
This is all in Nevada.
I think that covers all appearances as far as parties are concerned. And it's my understanding this is
he is actually
Mr. Phillips' motion to strike non-conforming brief. Is that correct, sir?
Yes, Your Honor.
Okay. Do we want to have this matter reported?
It's not necessary from my perspective.
I understand. I didn't think so, but I have to ask that, sir. Anyway, sir, you have the floor.
Well, thank you very much, Your Honor. Basically, why we're here today, back on March 17th, Falcone, who is the owner of this Our Nevada Judges, filed a media request. And let me say right at the outset that there is no issue about whether or not the media can, whether Our Nevada Judges can do the broadcasting. The judge in this case ruled that media coverage is permitted, and so that's a non-issue for the purposes of this hearing. What is an issue is that my office filed a motion for reconsideration of that media request. And then in response to the plaintiff's motion for reconsideration, Falcone, on behalf of Our Nevada Judges, filed an opposition to that motion for reconsideration. And so the issue here is whether a non-party can file an opposition, rather, to a motion for reconsideration. And it's the plaintiff's position that that's not something done simply because Rule 11 forbids it. The issue here, again, is whether non-parties can file oppositions. So now, under Rule 11, and this is very specific, every pleading must be signed.
And sir, I don't want to cut you off, but I get it. I understand.
Okay.
Okay, Rule 11 gets brought up a lot. I've watched a lot of Nevada cases because of Our Nevada Judges. Also, the Veterans in Politics International. I've watched lots. I can't even tell you how many hours of Nevada family court cases. Rule 11 is brought up a lot. I don't know the ins and outs of the Nevada laws. I've flown over Nevada, but I've never actually been to Nevada. So I'm not familiar with their rules, but I do know that the Rule 11 gets brought up all the time by people that, I hate putting it this way, they're more adversarial towards the courts. So they're more aggressive with the court, I think. I don't know. I just know it gets brought up a lot. And I don't think that when they claim Rule 11, it doesn't normally go in their favor. If I remember correctly. But then again, you can't count on my memory. I do have a traumatic brain injury. Half of my left frontal lobe is missing. So essentially, I only have 3/4 of a brain. So you can't expect a whole lot out of me. That's my joke about it.
I just want to make it real simple for you. I get it. I mean, non-parties to cases.
Is making a Rule 7?
And I realize this is a very unique matter in this regard. As far as I'm concerned, the media, all they have to do is show up and set forth their position. It is what it is. But you're right. Unless you're a party to a case, you shouldn't be found. I get it.
And so the only remedy we're asking is that those briefs be stricken. Again, the judge has already ruled on the media being able to cover it, but I think that those oppositions should be stricken. In fact, with all due respect to the court, this is not something where the court can exercise discretion. The Rule 11 says that the court must strike the brief, and so we're asking the court to strike it.
I understand. I get that. Okay.
I really enjoy
anything else, sir?
How Alex.
Okay. Well, I think I would add also, just very briefly from a public policy
those
standpoint,
information
I
piles.
think that a media entity is supposed to be neutral.
On
They're basically supposed to be a passive conduit for the broadcasting of proceedings. But you can see this person here has a real interest in wanting to do this, and I think that's what's inappropriate is the fact that he's trying to be adversarial by opposing, and I don't think that he has a right to do that. So Again, if the court
I don't
wants to
think
strike
it's
the brief, we're
adversarial
hoping the court will do that.
at all. I think he was
Right,
trying to
right. And for the record, sir, I get it. And this is multi-layered without going into detail of all my thoughts because it's really unnecessary. At the end of the day, you know, when you file motions and or oppositions in cases, that's typically reserved for the parties to the litigation. In fact, that's what's required. From an appellate perspective, they have procedures in place as it relates to amicus briefs being filed by parties that are not, I should say individuals that aren't parties to cases, but it might be an issue of public interest and they file and seek requests to do that.
This is exactly what Alzheimer's is talking about.
And we don't have that for district.
Public interest.
You know, there's no amicus provision. And I've had entities come in, various associations, and I know some other judges will listen to it, but I ask them because at the end of the day, I try to be tethered to what the rules require because that gives consistency. And there's no mechanism in place when it comes to the trial courts. This is what we're going to do, and I understand the position of the media entity as far as access and those types of things. All we have simply pending right now would be a motion for reconsideration. What I'm going to do is this, and as far as the motion as far as the motion to strike non-conforming brief, I'm going to follow the mandate of the rules. I'm going to grant that relief. Notwithstanding that, and I do understand what the public policy is as far as state of Nevada is concerned as it relates, and I should say the trial courts and our Nevada Supreme Court as it relates to media access. And anyway, it's a real simple decision. I'm going to have Mr. Phillips prepare a real simple order on that issue because you do have to be a party without even, that's so fundamental and you have to have standing. You do. And so that's going to be my decision. And we'll deal with the motion for reconsideration, assuming one's filed. Because I'm looking here, let me see here. We have a net, what's this set for the 25th? Plaintiff's notice of motion to strike immaterial and scandalous matter. I guess that's not really relating to this issue today. Is that correct, Mr. Phillips?
Yes, I believe that's a motion to strike another matter.
Okay, all right. So anyway, that's what I'm going to do.
We're going to go to the next video. That one definitely talks a lot about.
Okay, we're going to move on. Next up happens to be page 8 of the calendar today, and that's T. Phillips versus Jennifer Abrams et al. Let's go ahead and set forth our appearances for the record.
Good morning, Judge. This is initial T period Matthew Phillips.
You initially sued the attorney.
Good morning, sir.
And he is.
Good morning, Your Honor. Adam Prinsteiner on behalf of defendants Dave Schoen and Mark DeCero.
Good morning.
So T. Matthew Phillips has made claims in court and in court filings that I am a paid employee of either Jennifer Abrams or Marshall Willick or I guess Nevada Family Court. And I don't. The only connection that I have to these guys, it started with the Michael McDonald divorce cases on Veterans and Politics International. I found it because let's see. Well, I don't want to lose the place. If I were to show you guys like my YouTube, when I just hit the search bar, like literally the first thing that shows up is like true crime documentaries, cult documentaries, true crime, law and order, like those are what I watch. So it was happenstance that I ever found all of this stuff. And I know I've said it before, and I know he doesn't believe me, but it's true. I'm not paid by any courts to do anything. I mean, I get paid by Google now for my channel. And that actually, I didn't even want to have a channel to start with. There's a couple other law tubers, and Alex wanted me to do more like our Nevada judges, which hopefully someday I'll get to that. But anyways, let's just watch this because this can get pretty entertaining. And I will be right back. I need to go grab something. I've been sitting here on the floor for several hours, so I am very uncomfortable.
Morning, Your Honor. Joseph Guerin
I'll be
for
right
Jennifer Abrams and the Abrams Law Firm.
And good morning, sir.
Good morning.
And does that cover all appearances?
Yes, Your Honor.
All right. Just want to make sure I didn't overlook anyone. All right. And okay. And let's go ahead and do we want to have this matter reported?
No, thank you, Judge.
All right. What about from the defense perspective?
On behalf of Abrams, this is Joe Guerin. We do not need this reported, Your Honor.
Okay. All right. I didn't really think so either. Okay. I understand. All right. And so anyway, once again, good morning. And Mr. Phillips, it's my understanding this was your motion to strike. Is that correct, sir?
Yes, Your Honor, that's correct.
Okay. You have the floor, sir.
Well, basically, the defendant's attorneys are defaming the plaintiff in a manner not unlike what the defendants have been doing. These are criminal allegations alleging the plaintiff is practicing law without a license. Well, let me say unequivocally, I know it's kind of hard to maybe to define the practice of law, but the way plaintiff signs his pleadings, nobody relies on that, and certainly nobody relies to their detriment. And the manner in which the signature is affixed, it's not taking a gig away from any local Nevada attorney, so it certainly is not actionable as a practice of law. And defendants have actual knowledge of this. The reason I say it is because they've never filed a state bar complaint. If they thought there were a problem, they would file a state bar complaint. So the question arises, why are they doing this? Well, the truth is they're doing this because they want to continue the smear campaign of the plaintiff. They're doing exactly what their clients are doing. And it's the plaintiff's argument that these allegations are scandalous. Within the meaning of Rule 12F, the court can strike a scandalous matter. I would also say that these allegations about the unauthorized practice of law are irrelevant. And the reason they're irrelevant because they tend to prove nothing in the case. They don't prove any affirmative defense. If the issue is defamation, it's not affirmative defense to say that the plaintiff practices law without a license. It's kind of silly. But the part I find most offensive, and I hope the court frankly will address this, the points and authorities cited by the Lewis Brisbois law firm are just completely, they miss the mark, to put it mildly. They cite an Ohio case where a Kentucky lawyer got in trouble with the state bar and was ultimately disbarred because this attorney purportedly signed his name in Ohio. Well, that's not what the situation is. The attorney didn't get in trouble for signing his name. This Kentucky attorney was in fact representing clients in Ohio and charging them money. The case before the bench right now is totally different because the plaintiff, of course, is self-represented. And just to make this kind of quick here, the reason they're doing this also is I believe they have no viable defenses to the claims, no viable defenses to this lawsuit. And frankly, they're just wasting time trying to paint the picture of the plaintiff as being rogue and miscreant and all those other things. And that's basically it, Your Honor.
Okay, thank you, sir. We'll hear from the defense.
Good morning, Your Honor. Adam Prinsteiner on behalf of Dave Schoen and Mark DeCero. I would agree this is a waste of the court's time. However, I'd point out this is an issue that's been raised by plaintiff. This is really a holdover argument from the motion to dismiss briefing that the court previously ruled on in favor of the defendants. These are, plaintiff is referring to prefatory comments that were in the beginning of the briefs as to the fact that his pleadings have been signed and are continued to be signed by an out-of-state law firm, his firm. I believe it's not scandalous for that reference to be made, given that the plaintiff continues to sign his pleadings that way. We have not taken a position as to any bar complaint, despite plaintiff's repeated invitations that we do so. Obviously, there's very good reasons why we do not reference disciplinary proceedings before the court. Nevada has rules on those. So that's why we've ignored those invitations. We think this is not a good use of the court's time, and we don't think it's scandalous to make a remark about something that's undisputedly in the court record. Thank you, Your Honor.
Your Honor, this is Joe Guerin for the Abrams defendants. What's troubling to me about plaintiff's insistence that he identify his California bar license in the caption is there's an attempt to somehow let the world know that he's a lawyer and he can practice law. Nevada has some pretty clear rules. For example, Supreme Court Rule 42, which requires that attorneys go through procedures if they want to have a pro hoc admission. Now, I understand that counsel is representing himself, but he's not a lawyer in Nevada, and it's misleading for purposes of the court record to have all that information in there. I don't know why it has to be in there or what it's adding to the case. So there's a collateral concern about the implications under Rule 8.4. So I think the motion should be denied, and the court should instruct plaintiff just to do a typical pro se caption as opposed to the pomp and circumstance of a California license. Thank you, Your Honor.
All right. Mr. Phillips, sir.
Yes, I'd like to just say real briefly that Mr. Pernsteiner said these were passing comments. They're not passing comments. They are pointed allegations, and they're intended as such. I would say also that these pleadings remain in the public record, and even though the arguments are no longer viable because the hearing was disposed, the pleadings still remain in the public record. I would like to point out something that both of my able colleagues somehow missed, and I don't know how they missed it, but if I could turn the court's attention to the pleadings, specifically the upper left-hand portion of the caption page, right below the name, it has a state bar number, and below that it says not licensed in Nevada. And for the benefit of my colleagues, again, not licensed in Nevada. I don't know how anybody could think I was playing hide the ball here or trying to impersonate myself. The reason, if I could be, this might be too much information, I don't know, but many years ago, this must have been 25 years ago, I testified in a fender bender case. And a few moments into the testimony, it came out that I was an attorney. And the judge was mad at me for not immediately identifying myself as an officer of the court. And I was reminded that when an attorney appears before a tribunal, they are supposed to identify themselves. So that is what I'm doing. But there's no pretense of practicing law without a license because, again, for the benefit of my colleagues, it says not licensed in Nevada. This has never been an issue. I've done several cases here in Nevada. That part about the law offices of T. Matthew Phillips is a template. It just comes up on my pleadings, and it's never been an issue in several years of family court litigation, in other private litigation. It's just coming up now because, again, defendants are on a mission to try to slur the good name of T. Matthew Phillips. And with that, Judge, I will rest.
Okay, here's my question for you, sir. And for the record, I don't mind saying this. I did look at the caption in the upper left-hand corner of the pleadings in this matter, and specifically where it sets forth T. Matthew Phillips, Esquire, California State Bar, and it gives you a state bar number, not licensed in Nevada. And here's the thing, and I don't know the answer to this, but and it could be a gray area. From a practical perspective, clearly you have a right to represent yourself. You know, we all know that. I don't necessarily see how this rises to the unauthorized practice of law by having it there, but maybe it could lead to some confusion. I'm not sure. Just as important too, I see like the signature portion of the pleadings. And for example, I'm looking at page 2 of the motion. And of course it has your electronic signature. It has what would be appropriate as far as you're representing yourself under your name.
Some food at
And then it has the law offices of T. Matthew Phillips, you know? And so my question is this, what does that really add? And then we'll get to another issue. What does that really add to the case? Because to be candid with you, sir, I know you're a lawyer, licensed in California, you know, and I don't know why that judge got mad at you, but I wouldn't get mad at anyone for not disclosing to the court that they were a lawyer. I mean, you know, unless it was germane to the case on some level.
Honestly,
Typically, lawyers have a
I
right
would
to
understand.
represent
I
themselves.
get why a judge would get mad about not.
It's like an average Joe or Jill
for
has
jury
that right too.
And you didn't
And
disclose
so from a pleading perspective, what does that really add?
Well, if I can anticipate where Your Honor is going, and respectfully, if Your Honor wishes that that portion be excised where it says Law Offices of T. Matthew Phillips, I am happy to comply.
Right. Okay, I got you. And my last question for you, sir, and I just want to make sure I understand, because I'm looking here and the points of authorities are very short. As far as when it comes to striking, the motion to strike, I just want to make sure I understand what portion of, I think it was of the reply that you wanted stricken from the record.
I think in the reply brief, I'm pulling it up right now, on the last page, we're simply, we indicate the portions that we want to strike, I believe is what it is.
Okay. Here, if I missed it, okay.
Or it may be in the moving papers.
Yeah, okay. But the reason I'm asking that, I'm just wondering, so I have some particularity as far as page and line number.
Yes, it would be defendant's reply brief that was filed on April 6. And this is the defendant's reply brief at page 2, lines 9 through 12. And defendant's reply brief at page 4, lines 5 through 15.
Food that is being tossed at her. She's starting to, she's got cataract.
As far as page 2, lines 9 through 12, what does that say again for the record? I just want to make sure I'm clear.
Okay, let me get it here.
Wait, can't see it.
I see here. I got
my
it
other
right
elbow.
here. Matters to be stricken, summary and conclusion.
Yes. And the exact language is on page 4 of the moving papers, where it says plaintiff T. Matthew Phillips is a non-Nevada licensed attorney who appears to be engaging in the unauthorized practice of law. And the second, what we believe is offending portion, is the paragraph on page 4 of their brief at lines 5 through 15.
And what does that say?
That says that the absence of an attack by plaintiff raising the issue of the unauthorized practice of law should be deemed by the court to be an admission. The unauthorized practice of law is not an issue to be taken lightly in Nevada, as it carries with it swift penalties.
All right. And after I pointed that out, and sir, thank you for the clarification. After that was pointed out, any comments from the defense on those two issues as it pertains to the unauthorized practice of law?
Your Honor, Adam Prinsteiner, again, on behalf of Dave Schoen and Mark DeCero. I do not believe this reaches the level, threshold of what would be needed for a motion to strike to be granted. This is argument in a reply brief that was previously before the court. As to signing of pleadings that aren't disputed, that the court's already addressed. I would ask that the motion be denied.
All right, and I think co-counsel from the defense, I just want to hear from you.
I don't think that this would fall within the unauthorized practice of law as the court defined it in the case of In re Lerner. It's troubling because it's misleading, but for purposes of argument in a pleading, I think that, considerations of the litigation privilege truly preclude the court granting this motion. I mean, we're in an adversary system, and if they want to polish their allegations in a certain way, I think they're entitled to do that. I don't think that it necessarily requires a separate Rule 12 motion to strike.
I had my room
a pleading
set up,
that's
I had
already
my studio
been
set
ruled.
up. I'd do that right now.
I
Back.
understand. I did.
Thank you.
And you're welcome, sir. And we'll get Mr. Phillips, you get the last word, then I will.
Well, I would just say real briefly, litigation privilege would insulate them from a lawsuit for defamation. I mean, if this were not in connection with a pleading, I would sue these counsel for defamation because it is defamatory. But that being said, these are criminal allegations. They have no place in the pleading, and respectfully, we would ask the judge to strike and excise those portions.
And all right, and we have a clear record. This is what I'm going to do. And two things. As far as future pleadings, Mr. Phillips, what we're going to do is this. We're going to have you, I want to make sure, we're going to have you take off the law offices of Matthew T. Phillips when you sign it in the future. As far as the specific motion is concerned, as it pertains to the unauthorized practice of law. Interestingly, I was on the State Bar Unauthorized Practice of Law Committee for about 10 years, well before I became a judge. And the way I look at this, and I think this is, we just can't overlook it when it comes to lawyers and professionals. Potentially, it could have a significant impact making that type of allegation. And so, as it pertains to the provisions that specifically point or reference to that, for the record, I'm going to grant the motion and have that stricken. That's what we're going to do. And I'm going to have you, Mr. Phillips, prepare an order, and it's going to be circulated. I just want it written with some findings based upon our discussion. And once you're done, you're going to circulate it to the adverse party, defense counsel. And if you can't, if they can't agree, and maybe not, and if we have a dispute as to the contents of the order, everyone's free to submit competing orders. But it should be a real simple order, Mr. Phillips. And so that'll be my decision on this issue. And so with that in mind, we'll go ahead and move on.
Your Honor, there is one housekeeping item in this case I'd like to raise.
Go ahead.
Address it. There's a June 3rd hearing currently set on the anti-SLAPP motion to dismiss. I believe the court currently has two proposed orders before it from the prior motion to dismiss. Both provide that date will be taken off calendar. I believe as we sit here today, it's still on the calendar, but I just wanted to raise it for the court's attention. I don't believe there's any disagreement between the parties that it would be taken off, given that there'd be presumably a new complaint, at which point there'd be a refiled or a new motion.
All right. And Mr. Phillips, you don't have any objection to that, do you, sir?
No, Your Honor. Thank you.
All right. I didn't think so. In fact, I kind of remember it maybe, I mean, we have a lot of cases vaguely. It was touched upon at the prior matter. But this is what we'll do as far as the motion to strike, the motion to dismiss pursuant to NRS 41.660, the anti-SLAPP provision, and also motion for summary judgment. we'll vacate that. All right? And someone can prepare, someone can, and sir, can you prepare an order for me on that? Just a simple one-liner? Was it's contained in the prior submitted orders, is that correct, sir?
Yes, it's already before your honor and previously submitted orders.
Okay, and that's fine. We don't need a new order then for that. But for the record, we'll vacate it just to make sure that there's no confusion. And that can happen very easily. All right. Everyone enjoy your day.
Thank you,
Your Honor.
Your honor.
Okay.
Okay, I am now. This is going to continue to play through. Let's stop this. I have they're unedited. I will tell you that they are unedited court videos from this last week. Let's see. Which is which? Who do we have? I don't. They're all they're from my phone and stuff, so I don't know the name of the videos other than what the phone assigned to them. Try to see if I can randomly pick something fun. Okay.
Step on the black line, face the camera, say your whole name. How you doing? I'm Adam Manley Dunn. Thank you, sir. I'll be right with you.
Completely unedited, guys. So I don't know. I'm probably gonna get this. This video is not gonna be allowed to be monetized.
Sure, DDC. We've got an add-on. What's that name? McCall is the name. Can you put them on camera too to be interviewed, please? Yeah, we'll see if they're here. Okay.
Sorry, not trying to be rude. My husband left his phone at home this morning, so he's the parts manager at a dealership, and the other girl that works in parts with him, I'm texting her, and I was telling her.
What was your name one more time?
Streaming.
Adam Manley.
I take precedence over my husband. Let me tell you.
Thank you, sir. All right, Mr. Dunn, you've got an old traffic matter where you missed a court date. When that happened, the judge issued an arrest warrant for you. You do have the right to remain silent. Anything.
So I've noticed, because I do watch hours of DDC, like I'm watching DDC stuff until like 3-4 o'clock in the morning. I'm no joke. I'm watching it through the night. I have noticed, and I'm sure this is probably pretty consistent across the United States, that a lot of folks are getting picked up on traffic tickets, like old traffic tickets. So what I have to say, you guys, take care of your traffic tickets. I mean, just deal with it. We're adults. Grow up. I mean, I know you can fight a ticket. Oh, I know you cannot afford things. But you know, you can make payments. You can ask the courts about that. If you learn anything from my channel, please let it be that, you know, you might get assessed fines and costs, but you can sort of set up some sort of a payment arrangement. You know, pay your tickets, because if you don't, you're going to end up getting arrested for something huge, but you're getting picked up on a traffic ticket that's like 4 years old. Just pay your tickets, people, especially if you live in Michigan, because we still need to fix the damn roads. Like, bad. I'm not joking about that. We have horrible roads.
You say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, the court will provide one for you. Do you understand those rights, sir? Yes. All right, this is ticket P1322668 with a charge of driver's license never acquired. That's a misdemeanor charge, sir. Maximum penalty you face up
Also,
to
if you don't have a
93
driver's
days in
license,
jail
don't
and
freaking
or
drive.
$500 fine. I'm going to
Please,
set
don't
aside the
drive.
arrest warrant, give you a personal bond, and enter a not guilty plea on your behalf. Your next date for that is a pretrial in front of Judge Evans on April 3rd here in 36th District Court. Now for your more serious matter, this is case 2305583, State of Michigan versus Adam Manley Dunn. Counsel. Thank you. Court will enter a not guilty plea on your client's behalf as to bond.
As to bond, Your Honor, he is a lifelong resident. He's 30 years old. He's currently unemployed at this time. He does have 5 kids. He's a lifelong resident. And Your Honor, these are non-assaultive. I'm respectfully asking the court to consider a personal bond.
Charges filed are in fact non-assaultive, but there's some other matters that need to be touched on. Got a history of attempt CCW, larceny from a motor vehicle, felony firearm. More importantly, in the investigator's report here, apparently he was outside of the subject location, appears to be the residence of his child's mother. And while getting belongings from the car, stated, quote, "I'll shoot this bitch up," and pulled out a gun. So I wouldn't exactly say it's non-assaultive.
That's a
Here's what we'll do, sir. While this case is pending, you are not to possess a firearm or any other dangerous weapon. You're to have no contact with Miss Mincy. That means don't call her, don't text her, don't go to her house. Don't reach out to her on social media. Don't have anyone else do any of those
No contact
things
means no
on your
contact means
behalf.
no contact,
Is
not
that
by
clear?
you, through social media, third party. You can't even send her
Your client working,
a
counsel?
telegram through a store. Some people
Further,
apparently
you on
don't
a
understand.
GPS
Because
tether on house
no
arrest,
contact.
sir. If you leave your house, you're going back to jail. Is that clear?
Stay home.
Court will set bond at $5,000 personal. Next court date is March 15, probable cause conference, March 22, preliminary exam, both in front of Judge Sabri here in 36th District Court. To be clear, I'm setting a personal bond because of the charges that were filed, and had the more assaultive charges been filed, I'm certain I would do something different with the bond. But that's what we'll do today. Thank you.
Sorry about that. I was recording that in the morning and it was my alarm clock telling me I had to get ready for something. Let's see. Let's see what else I have stored on my phone. Because I have Luna, please stop. Okay. So yeah, I am using my husband's Chromebook. I actually have a laptop, but it's super slow. Like, I can't really even stream. If I try to watch like Netflix, it stops every 5 seconds, I swear. But this is just what I have saved on my phone. I have offloaded, I don't know how many videos onto my external hard drive that I have, and then I have my iPad, which actually has less. Okay, Luna, you just popped my hip out of socket. That hurt. Now my leg's numb. Sorry. So when I say I'm like working with very bare bones basic stuff, I am. I wanted to show you because I went to a different room. So I'm making a documentary. It's a slow going process, but I literally bought this camcorder thing off of Amazon. I don't know how well you guys can see that. It says welcome and goodbye. It is an IR camera, though. That's pretty cool. I may end up having to go do some ghost hunting or something because Michigan's haunted as heck. Anyways, it was like $180 or whatever, and I got a memory card and a better tripod than the one that I had. This is the equipment I am working with to film a freaking documentary. So when I am saying, join my membership to help support my channel, literally you are helping to support just even getting better equipment. My documentary is actually about the dentist that I went to as a child. He was convicted of 15 counts of criminal actual stuff against this kid. I think he was started when he was like 4 or 5 and it went until he was 10. I've actually become a very good friend I've become good friends with him. But like I have PTSD from the dentist. I had a freak out at the dentist one day. What? Okay, sorry. I couldn't read the screen because I forgot to put the reading glasses on. Luna, you got a fat butt, girl. Sorry. I had a PTSD reaction one day at the dentist, and I didn't realize it was as bad as it was. I said this a couple of times, but I had a coworker I was actually on the showroom or whatever. I was working at a desk, and I normally didn't. I just was too cold where I was working, so I had to go sit through its heat. And a girl, she reached around me. She had come up behind me, reached around me, and grabbed the handset phone because I entered something wrong when I answered the phone. And that, because I had already been triggered, it made it worse. I literally packed up like all my stuff. I made my husband pack all my stuff up, put it in my car, and I kind of quit. Not really quit. Like it was bad. But like when I realized that was PTSD that did that. And it was from being at the dentist because I didn't have my AirPods. I had lost them, and my actual like plug-in ones to my phone, those are in the desk drawer. I now have two pairs. I can only see part of the screen, sorry. I have 2 sets of AirPods now. That way, like, if I get caught out in public or whatever, they might die or whatever. I have ways of coping. But that day, I made a post on Facebook about it. Like, holy crap. This dentist was my dentist for a couple years when we were little, when we first moved to Michigan. And even though it was never CSC with me, he still was, he would, like, if you try to wriggle or make noise, like, he would grab your shoulder, but, like, dig in with his fingers. I've been slapped. I've had his big-ass hand put over my mouth and nose and told to be quiet. I've been strapped down to a dentist chair. And I was like 8, 9, 10 years old. I wasn't little. He would put in lots of shots of Novocaine, but not actually wouldn't be very much. So your gums were bruised. He'd put you on the nitrous oxide, he'd crank it up, and he'd walk away for like over an hour. I had been locked in, he had a side room, I've been locked in the room unsupervised because my sister was there and my sister was scared and I had to have been making noise or whatever. But I never even talked about this with my sister other than, we hate going to the dentist. Who doesn't? And like, I didn't talk about it with my sister. I never talked about it with my parents. Then again, I was young. I was like 10 or 11. I didn't know any better. But when I made that post on Facebook, I had so many people come forward, that people I actually did go to school with, but it was a different town than, it was like a couple towns over. And they're like, oh my God, he was my dentist too. He was horrible. He did this stuff to me. And then I was getting comments from people that kind of grew up in the area, but I didn't know them when we were younger. I know them as adults. And I had adults coming forward saying, hey, he did this to me. And I too, like, have bad dental issues, all this stuff. And then I had a friend that was a nurse practitioner, and we were talking about it one day, and she goes, "Oh my God, that's who my husband saw. He can't go to the dentist. Like, he can't because of the trauma." Well, so I made a single post later on Facebook because I was kind of like, how can I get this story out? Like something needs to be said. And keep in mind, this is Lansing, East Lansing, Michigan State University. This is the same area where Larry Nassar practiced. In fact, the dentist office and where Larry Nassar's former office is at MSU Sports Medicine is, I don't even think 5 miles apart. So it's close proximity. And I thought about that. That was like in my head, like, how can I get it out? Because I talked to my sister finally the first time ever, and she goes, "I can't talk about it. I have 2 young boys that have to go to the dentist." And I was like, what the hell did he do to her? Like, just the trauma or whatever. And I thought about it from here, and I'm like, I gotta make like a documentary or something. Something needs to be done. So then I made another post on Facebook, and I put it in a local networking group. And I'm not joking. I've had contact with over 35 people that were patients of his or staff. I've had parents of former patients come forward and reach out to where, like, it was a couple hours after I made the post because I'd put an email in, and I had people emailing me, sending me messages on Facebook, commenting on the post on Facebook. I was kind of like, whoa, I thought maybe I'd hear from 1 or 2 people. I did not expect to have 30 some odd people come forward. And those are the ones that reached out. And I'm talking like siblings where they have 3 or 4 different siblings that also went. But one of them, the one that reached out was the one they had contact me. So I've been, interviewing. I don't know what I'm doing. I'm not a documentary filmmaker. I still am uncomfortable even being referred to as a journalist because I do cover Michigan court and Michigan crime. So I bought this camcorder. I literally just finished made the last payment on it yesterday. But we've talked, and I've had a couple production companies reach out to me, and I've kind of said no because I've made promises to my fellow survivors. And if that asshat that comes in here talking about how you can't be a survivor of torture, you're just a victim. No, we're not victims. We survived it. We're still here. We're talking about it. Anyways, don't even say that crap to me. I'm a survivor on many levels, and so are most of these folks. I was getting messages and emails from people asking, was it this type of a doctor? Was it this kind of a dentist? Did this person happen to also have a practice in this city? We're talking hours away from, all over the place, you guys. I'm not joking. The sheer number of different doctors and dentists that I've had, former patients reach out to me about, this is a big problem. It's a huge problem. And people don't have a voice. People don't have a voice. I have this little tiny YouTube channel, like not even 2,500 subscribers, but I'm giving us a voice. So like I said, when I get the revenue, whatever, if you send me a super chat or whatnot, that all of that is going into being able to get this documentary done. I have my camera, my video camera, right? And I have the memory cards, but our laptops, you can't look at the memory cards on our laptops. I have to get some sort of a memory card reader. So I'm literally working with very basic stuff. If you guys, I don't know who's going to watch my videos. If you guys know of a production company or someone that has equipment to film, because I don't know the quality of the image on this camera. I don't know how well the sound picks up. And I can tell you this, I don't have time. I don't have the money to be buying a good camera for a couple $1,000s. I don't. I'm disabled. I'm 100% disabled, and then I do my YouTube. So yeah, I'm gonna try and figure out how to do some sort of a fundraiser, although it's weird because, like, I was on a broadcast and it will be streamed. I think it's Monday, and we kind of talk about this stuff. We talk about the documentary and all that kind of stuff, but we have to figure out some way to do funding. Big problem is, I filed a Freedom of Information Act with the county. Michigan changed the law. They changed some laws very quietly. So we all know courts are public. It's all public record, stuff like that. So Freedom of Information Act, a FOIA Act form, is essentially you're requesting information from whatever. So I requested all the documents, the evidence, transcripts, everything from the Wendell Allen Reset trials, the mistrial, all of it. And Ingham County kindly points out that, well, they don't have to honor your FOIA request at all. They can just say no, even though court records are public record. They can say no because they changed the rule. So when I saw that, I was like, oh God, this is going to be nothing. But then I got a message. They were asking for an extension, which if they need more time, I mean, he took his last plea deal in 2016. So it was a long time ago. And I think the first trial started in 2012. He did actually serve, I want to say like 2.5 years in prison. And then he won his appeal, which is a different story. But, it's been years ago. And like the first trial was a mistrial. Then there was a second trial, which is insane. And then the appeals, and he appealed. He actually was able to get his dental license back, which is really scary, because of all the tortures and the CSE, and that it was 15 counts, just one child. That was just one child, mind you. Ryan that came forward. The one that he went to the police about it. One kid found guilty for 15 counts of diddling a kid. And that is not including the torture and agony that he did to literally every single one of his patients. Okay? When I say this guy is vile and evil, he is. He unfortunately still lives here in the area. I hope I never see him, because there's going to be a showdown. There's going to be... my husband's going to learn just how loud I can scream and yell. Let's put it that way. But I have made a promise to my fellow survivors that we are in control of this documentary. And I've told them, because it's scary. This guy trying to get the Freedom of Information Act. County said it was going to be, I need a down payment of $300 and something. And it's like, it was over $600 for the documents that they have. I have no idea what it all is. I don't know how much it is. I don't know how redacted it is. But I don't have money. I don't even know where to start. Like, I've looked at some fun, like, not scholarships, like grants or whatever, for like documentary filmmakers, but they weren't open. I'm thinking they're probably going to start opening back up because it is kind of film festival season. I know, like, South by Southwest is right now, and there's a bunch. I think Tribeca is also this week. Actually, South by Southwest might be over. Anyways, so there should be like scholarships or grants opening up, and they have them for like projects that are like in the very beginning investigatory stage, which is where I'm at. I'm also facing corruption. And I know we hear that a lot in court videos, that the courts are corrupt, that lawyers are in league. Okay, but this is straight corruption. So the dentist was found guilty. First was a mistrial. I don't remember why it was a mistrial. The second hearing, the second case, found guilty of 15 counts of CSC on a minor, and I don't know how many of child abuse. And he went to prison. He was actually at Jackson Prison, and he got jokered. And I was told a story about that one of the nurses that was there was also apparently one of his patients that he did a lot of damage to. Like, she still has had to have surgeries on her jaw as still. And she walked away. Didn't do nothing. Honestly, I'll tell you what, I would have walked away too. That guy is a bad man. But so he got an appeal based on a technicality. Then all of a sudden, the prosecuting attorney for the county, Stuart Dunnings III, he's the one that said, in 2013 or whatever, we're going to push all the way with these cases. Gave the dentist one hell of a sweetheart deal. Plead no contest to one count of child abuse. Time served. No longer a registered offender. No fines, restitution. It's all done. You're done. Now, I do personally know, well, professional but personal as well. I've gotten to know the public defender because, like I said earlier, I was a domestic violence advocate and stuff like that. So we worked with them. And he knew me. I'd been in the courthouse and he'd say hi to me. It was like a year later. And I'll say this, when there's people with power that you're always going to hear rumors, the sheriff, the police chief, they do this, they're picking up, I don't know the PC term for it, ladies of the night, it's all this corruption, there's drugs. It happens. It's because of their position. But this is true. He ended up pleading guilty to, I want to say, I think it was like 11 counts of human sex trafficking. The prosecuting attorney for the county, the FBI came in and did an investigation, and he pled guilty to like 16 counts of human sexual trafficking. And this is and we're talking like the rumors were there. He was already being investigated by the FBI and the DOJ. So that was already taking place. And this is the prosecuting attorney that gave a convicted sex offender against children. And the judge said that he's a sadist because his pleasure is to torture children. And yes, he tortured us. Like, beyond belief. It was torture. He got out pleading no contest to one count of child abuse. That's corruption. I'm trying to make a documentary. Oh, by the way, you can look it up. There's only 2 news articles. Wendell Allen Reset. 2 news articles. There's some site like Bad Dentist or something where people have listed reviews about them. A lot of former patients have like left reviews. But think about that. One kid, there was 15 counts of CSC against a minor, like young minor. And then all of a sudden, there's only 2 articles about it. Why? This is the Capitol. I mean, he was literally everyone that had kids, like he was their dentist. And he has money to this day. He was also convicted of insurance fraud against, I think it was Medicare, for overbilling and stuff. And that is going to be talked about in the documentary, how he did that stuff. But I'm literally taking on a corrupt county. And I hate saying that because I don't want to. I want the truth to get out. I want others to know that they are not alone. They're not the only one that survived this. Because that's one of the main things is everyone has said, I thought I was the only one. So I'm probably going to end up making a shirt. I don't know, do some merch to help fundraise. But I made a promise to my fellow survivors that up until, like, literally up until the last second, once it's already, like, ready to go, you can't. But up to that point, you can change your level of involvement in the documentary. So, like, because of my brain injury, I record, when I talk to everyone, I record me talking, and I have it on speakerphone. That way I can look back and be like, oh yeah, that's what they said, or oh no, it was that person that said that. So I record those calls, but I've said, like, if they don't want, like, they just kind of want to be included as far as like sort of statistical numbers or whatever, we're in control. But having a big production company come in and trying to help, that's not gonna, I don't think that's going to happen. So anyways, when you support my channel, you are also supporting literally hundreds, if not thousands of victims of children that were tortured and abused by this single dentist. And that's not even counting everyone that's reached out to me about other dentists and doctors in the area. And it's time that we had a voice, you guys. We have a voice. Let's see, we're going to go back. What is this guy? I don't know. Let's check out this video. Sorry, I got boring there for a minute. I'm having problems with one of my new medicines that makes me... Oof.
Black line, face the camera, say your whole name.
Oh, I just did him.
Adam Manley done.
Dang it.
Thank you, sir.
I just did his case. Let's see. So you want to see this, the yarn that is wrapped around my neck? My nephew, he'll be 5 next month. Yeah, he's going to be 5 here in about 6 weeks, I think. Something, I don't math, sorry. He's 4. He thinks rainbow is an actual color. I guess, I don't know if he actually understands that rainbow is comprised of 6 different colors, but he's obsessed with rainbow. And I happen to have some hand-dyed yarn that is rainbow, the RGBV, basically, just the basic primary colors. But I have several skeins of it. I knew I had some. I knit him a pair of socks, and he got them on Christmas Day, and he wouldn't take them off. I don't know if my sister still has to fight with him to get them off at night, or she had to go in at night, like after he went to sleep, to take his socks off so she could wash them. I don't know if that's still the case. Wait, hold on. This is why I have reading glasses, right, you guys? Oh, duh, I'm not. I was like, I know I have more than that. Go back to March. Beginning of March. See how this one is. I got these at like Dollar General or something. They're way too strong. but they look sassy, I think. So anyways, I'm knitting another set of socks for my nephew.
$20 oversight fees and a $100 pre-sentence investigation fee and substance abuse evaluation fee. The total fines.
I don't know
costs,
if I
and fees.
can slow that down. Okay, we're gonna take that away. I actually was experimenting for a minute about if I could record the videos at a faster playback speed, which would inevitably take up less space on like my phone and iPad. If that were functionable, if it would work. It works for some judges. I know Judge Gauthier up in he's up at the tip of the glove up by Alpena and stuff. Him, I can't match. If I speed it up, slow it down, it's not the same. So I have to record him in a speed that I want. Let's see. Where are these? Just like saving everything 4 or 5 times. I don't know what's going on with my stuff. Okay. You guys can't see my screen, it's just spinning. Gonna make me dizzy. The heck? They're both plugged in, so I don't know why. Anyways, my nephew lived his socks, so I had to make them about a half inch longer, but that was Christmas, so I'm almost done with the second sock. Then I'm gonna actually knit the next size up for him. He's gonna be 5, right? So my older nephew is 6 or 7. I forgot now. He is the same big head size as his older brother. That's a couple years older than him. That boy's gonna be a bruiser. Like he has attitude too. He can be a little. January. What do we have from January? Possibly good stuff. Well, that looks like a big old hearing. I literally have no idea what these files are. Anyways, for those of you that were here, I do appreciate you coming in. What? Oh, let's see, Miss Sinatra.
On that.
Sorry, trying to get like a good spot. Too far. Take it.
Charge the defendant with witness intimidation. That's a felony. He is set for a probable cause conference on March 2nd with Judge Simpson. Cash bail is $25,000. Surety, cash surety.
Whoa.
So last thing I'll say is I just served counsel, Mr. Collis, and the court with a forfeiture by wrongdoing motion with the people's intent to use statements based on the defendant's actions of preventing this witness from coming to court, forcing her from coming to court. And I don't know if Mr. Collis is ready to proceed today. I just literally gave it to him this morning. But that's the reason for people's position on not being able to proceed with that witness, but we do have a valid motion.
Your Honor, I appreciate the people filed this motion. However, they've had the opportunity to file this motion for 3 or 4 weeks, and they have not done so. They've instead filed the witness intimidation charges and served this motion today. The witness intimidation charges were filed with couple of weeks ago, I think, and I was appointed to that, which is again to be heard on this Thursday. In listening briefly to the phone calls, because Mr. Ganatra provided me with the phone calls a week ago Friday, and then of course we've had a power outage that has knocked me out of commission for basically Wednesday through Sunday, and I had a jury trial on Tuesday and Wednesday. Obviously, I haven't been able to do much more than cursorily review them, but in reviewing them, it doesn't sound like to me that Mr. Mercer is in any way trying to coerce Ms. Dunas from showing up here today. In fact, it's her asking him what to do. I've had no fewer than 5 or 6 phone calls from Ms. Dunas about essentially asking me what to do. And of course, I've not returned those calls because of course I can't advise her as Mr. Mercer's attorney on what she or should not or do. It does not appear that Ms. Dunas is going to be a cooperative witness. And here's the end run story about this, all, Your Honor. Let's assume for the sake of argument that we do get through and the people get their wish and they get a forfeiture by wrongdoing. Get to trial, none of these statements are going to be admissible anyways, and then the case is going to get dismissed. So it seems like a long end run to get to the same place. So if the people feel that they can go at some point in time, let them go at that point in time. But today, as it stands, and after several adjournments, I would ask that this case be dismissed.
Your rebuttal?
Well, actually, the forfeiture by wrongdoing carry over into circuit court as well, the motion. Furthermore, there'll be I would expect a 27B(c) motion as well to be filed by the prosecutor in circuit court because the defendant does have a prior DV conviction with the victim that's listed on this case, on these 2 cases.
Based upon the information the prosecutor has shared with the court, I will deny the motion to dismiss. You're requesting an adjournment.
Yes, Your Honor. It's going to take time to respond to this motion. Obviously, I just got served with it this morning. May we approach, Your Honor?
Sure.
Oh boy, we approach. Let's see.
Was the 28th? Is that?
Yeah, and that means that the next available date after that's going to be sometime in April, which I would assume would be like April.
Chris, what are you doing?
The other option, of course, is go with a different judge.
I was just going to say, can't we just set
It doesn't matter what judge we have.
You know, and
okay, how soon can you be ready to do it?
I think vote
1 week or 2 weeks?
Well, I think this is my fault because we're going to have to.
Sugar warning, an overweight person's going to eat food again.
On Thursday. So that would mean that it's going to be essentially a week from Tuesday. I would just say that
So 2
whatever
weeks.
judge, whatever
2
judge
weeks.
that's going to be.
Okay.
Yeah.
Do you know who's going to be doing the exams 2 weeks from today?
2 weeks from today, I'm not sure. I can check. I'm not sure it's going to be able to check with that judge though. Or people, but I'll reach out.
Okay. We could just set it through somebody.
Yeah.
Somebody's going to be here for sure.
All right. So I'm going to fend off dash homes while I'm doing this. Show. They do have lists of hearings. Each individual courtroom has their own docket online that you can search or you can look. The counties have it if you go to the county website. So there is a docket every day that's put out. Like, it has the case information, the suspect. But I'm not affiliated with the courts. I am like apparently independent investigative journalist-ish thing. I guess I'm technically media. So I would not go around and check every courthouse docket every day. Just because like Detroit itself has like 30 or something. There's a ridiculous number of courtrooms in every city, in every state. So if you want to know, you can just go to the county website and then they'll have a docket search that you'll be able to look up. Okay. And yes, they can be very, very frustrating to search because sometimes, what you think you want. You have to say things a certain way, and it's just kind of hit or miss.
Sure, I would hope so.
Here, so.
I asked for new representation, by the way, sir. I don't know why he did not mention this, but I chose to fire this individual, sir.
Well,
I would like to report. Yeah. So I don't know why he hasn't.
We'll deal with that in just a minute.
All right. I'm not quite sure why he didn't mention that first.
And no, my dogs are not starved. They are very spoiled. No! Okay, you really are going to just look at me like again, guys.
Yeah, that's fine. Okay. All right, my understanding is that the witness is not available on the 28th, and the defendant is going to have a PCC Thursday. So it was suggested that the best date to adjourn this, not making him wait that long, would be 2 weeks. And Judge Burke is here 2 weeks from today. So I'm going to adjourn the matters to Judge Burke's docket 2 weeks from today at 9 a.m.
Your Honor, my client, as he indicated and I indicated at the bench, now also wishes new representation.
That's the way it works, Mr. Mercer. Everyone is entitled to, if a person's indigent, meaning has no cash, everybody's entitled to be represented by an attorney.
Right.
However, the Constitution doesn't say you get to choose your attorney. Mr. Collis has been in practice a long time. I know him to be a criminal attorney, so your request for a new attorney is denied.
May I tell you my reason?
No.
What you mean your reason why you want him?
Yes, sir.
Go ahead.
Okay, now here's that, sir. I was aware that this was going to happen since the last court date that I came to. Now, I'm very, very confident and sure that he was aware of this as well.
What is this was going to happen? What do you mean this?
Forfeiture by this motion.
Forfeiture by Ron.
This motion. This was discussed at the last.
Well,
which was 2 weeks ago, sir.
That doesn't have anything to do with the fact that basically that was one of the things that Mr. Ganatra mentioned, but he also mentioned the fact that he alleges, it's the people's position that the witness isn't here because of your having asked her or told her not to be here.
Right.
So
This motion,
regardless of whether this motion was filed, I'm stating regardless of whether this motion was filed, the court would exercise its discretion and I would have adjourned it anyway based upon the representation.
Absolutely. And I'm not denying it, sir. My thing is this, sir, is that 5 minutes ago was that's the last time he has talked to me. I've been incarcerated for over a month. This gentleman has seen me a total of today and then the last court date. I have been blindsided by all of this stuff, but he's been aware of everything. So I'm just sitting in here, and I understand that you would have made your decision regardless, but you know what? I understand where you're coming from. And the fact of the matter also, sir, is that what he's saying about, it's my understanding that the accused victim has actually said that they I'm pretty sure that he's just not saying everything that needs to be said. He's not sticking up for me, sir. He's not doing his job, in my opinion.
All right, I stand on my ruling. Mr. Collis will continue to be your lawyer. I'm sure that if he needs to see you between now and the next court date,
I really hope so.
See you.
This judge was covering for Judge
We're
Simpson.
done discussing.
Thank you. Have a nice day.
No idea who he is, but he was covering for Judge Simpson. He's one of
You may.
I can't remember what the other, the judge that was with, the new judge that was with Judge Simpson for a minute. I forgot what his name was.
How do I accomplish that? They said I wasn't muted at the bench. I didn't know that I had.
Oh, you know. Over by once, twice, you know.
This is like Judge Kindergarten. Kindergarten judge.
I was sworn it was.
Yeah, this one bothers me rather than it's recording. Chris, and I apologize. I should have
Okay.
mentioned that.
So-
I'm still learning the system myself.
But again, like I thought that down, maybe. Okay.
That's supposed to have been
I'll-
trial run.
I know I didn't touch it, but I thought it was red.
Yeah, no.
Okay, all right. I'm just
Those are just some.
finish
some
this one here.
Okay.
John H. John, we had quite a few for a long time.
Trying to read a screen without me. Hmm.
Grand Rapids, maybe Rockport area. You have any?
Are you going?
No, you don't have a.
Oh, I didn't take my contacts out, that's for sure. We're playing random video watch. You talking to me? Who should stop is my dog.
Yeah.
Go back. Gentlemen at DDC, what's your name? You're gonna need to speak up again.
Matthew Spicer, ma'am.
Matthew.
I don't think I showed his.
Matthew Spicer?
Yes, ma'am.
Okay. Mr. Spicer, a magistrate in Chautauqua. Not only do you have a criminal matter, you have a lot of misdemeanor matters. These are misdemeanor matters that you did not appear in court. I'm going to let you know what they are. And all these misdemeanor matters are personal bond, no dollar amounts. Do you understand that, sir? Is that a yes?
Yes.
Okay. First ticket is P1004378. I have, this is drawing while license suspended. Next ticket is P1034092, count 3 only, improper plates. Next ticket is P1034094, count 1, driving while unregistered untitled vehicle. Count 3, driver's license expired. Next ticket is U237-91715. Disorderly conduct, unlawful to consume alcohol in public. Next ticket is U254-26815. Disorderly conduct. Next ticket is U307-20916. Michigan. This is selling bus transfers. Observe the above. Defendant selling bus passes at bay, placing U.S. currencies, placing money in front pocket.
Temptuous.
Misdemeanor. Next one is U452-81918, loitering, public area, public private property. Next ticket is U55757720, misdemeanor, alcohol-related violations. Next ticket is U623-52810. Entering without owner's permission.
Welcome to my
Misdemeanor.
stream. I'm
Next ticket is
literally
you,
going over
653-46210.
just picking the file off
Let's
my phone and
see.
playing it. I don't even know what they are.
Participating in a game of chance,
The old recording.
dice game, misdemeanor. Next misdemeanor is you, 663-64510, entering without owner's permission. Next ticket is you, 735-18511, misdemeanor, entering without owner's permission. Next ticket is 12444-535. Here, let's see, count 1, no operator's license on person. Count 2 is unregistered motor vehicle. Count 3 is no insurance misdemeanor. Next ticket is 337815, misdemeanor, open intoxicant motor vehicle driver. Next ticket is 361601. Next ticket is driver while license suspended. Next ticket is 365656. Count 1 only, driver while license suspended. Last ticket is 464553. No operator's license.
21,
Sir,
if I remember
Mr. Spicer,
correctly.
maximum penalty on each misdemeanor, it's up to 93 days jail and or $500 fine. Do you understand that, sir? Is that a yes? Okay.
Yes, ma'am.
I'm going to enter plea of not guilty. Court date is February 3rd, 2023. It is a pretrial in front of Judge Garrett. Sir, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. You have the right to an attorney. Have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, sir?
Yes, ma'am.
Thank you. All right, criminal matter. Case number is 190-455-64. You have an attorney. Go ahead, counsel.
Yes, ma'am. Frank Bird on behalf of Matthew Spicer, my client, waived his right to the formal lead. Provide the constitutional right to the same.
Mr. Spicer, I'm going to enter plea of not guilty, counsel. Court date is February 28th, 2023. Pre-trial in front of Judge Bryant. Mr. Spicer.
Yes, ma'am.
You need to go to court, sir. You're not going to court. You didn't go to court on those misdemeanor matters. On this matter, this criminal matter, on August 10, 2020, a warrant was issued for your arrest because you failed to appear at a prior court hearing. And bond was set at $500, 10%. And Mr. Spicer, I will also indicate for the record that I gave you a personal bond back in 2020. And I told you, go to court. You need to go to court, sir.
Oh.
Counsel, in this particular matter, Judge Brian has given the court authority to modify KP's bonds because it is just littering. It's over 2 years, or close. Yeah, it's over 2 years. Mr. Spicer,
A littering ticket from 2 years ago.
put up your right hand. Okay. Now, Mr. Spicer, I'm going to take you at your word that you're going to go to court next time. Do you understand that?
Yes,
Okay. When is your court date?
February 23rd.
No, February 28th. Let me repeat that. February 28th in front of Judge Bryant.
28th.
February 28th.
Hold on. You're changing it again.
Write that down for me, 'cause
All right.
I'm not.
All right. For litter. All right.
I don't even remember.
All right, Mr. Spicer, put your hand down. Put your hand down. Mr. Spicer, your new court date is February 24th. It's going to be February 24th in front of Judge Bryant. Do you understand that?
This poor guy.
Okay. Mr. Spicer, I don't want you to come back and sit in jail. So please, go to court. Take care of your matter, okay? Again, bond is going to be $500 personal bond. Okay, thank you, Mr. Spicer. You can step aside. And I'm giving them personal bond because it's non-assaultive. And this is 2 years ago, maybe. He has a change of heart and he will go to court.
Okay, sorry. Fritz is obsessively licking Luna's ear. He does that. He's very weird. Okay, random video. Oh, I don't want to share the screen. Oops, that was the wrong one. Sorry. I hit the wrong thing. Of course I did. Well, Creighton's and Bishop, thank you for coming out for the second that you're out here. I really appreciate that. I know you guys were alive. I had asked time served, and I was like, "What is your video over?" He's like, "I was like, how long are you gonna be on?" He's like, "When this video is over." And he did not clarify that you were then gonna jump on your live stream and then go back to his. So I appreciate the fact that you stopped by and said hi. I really do. So definitely appreciate the extra love. You know what? I'm tired, guys. So we've been doing this for a minute here. So what I'm gonna do is I'm gonna go, I don't know, take a nap or something. Make my dog stop licking obsessively. Also gonna work on editing videos. I think I'm gonna try and do some more live streams. And pink waving. Where I'll just have I don't know. I have not figured out my pattern yet. I just thought I would jump on today and throw out a couple of videos from yesterday that I thought were pretty good. And it turned out to be so much more. I want to thank everyone. So Chima Gwitch, big thank you for joining me today. I got to give a shout out and thanks to Alex Falcone from our Nevada Judges for coming on and that discussion. I'm actually going to section out that portion of the stream and post that as a separate video because actually it was very interesting. On that note, go hug someone today. Say hi to that person that you kind of just say hi. Tell someone you love them. Give them a hug. And be kind to yourself and be kind to others. And you guys have a wonderful evening. Oh, yeah. This is Michigan Crime Time. Signing out. I don't know. I need a better sign out thing than that, I think. Yeah, we'll figure that out, won't we, dogs?